first.
Okay.
And Your Honor, I'm Jeffrey Even, Deputy Solicitor General, also here on behalf of Governor Inslee, and I will argue the temporary restraining order motion.
All right, thank you. All right, so Mr. Ard, if you could go first, go ahead.
Yes, thank you, Your Honor. We think it's very plain. The court absolutely has jurisdiction over these claims. Obviously, we also think venue is proper here, but a temporary restraining order is initial emergency relief. It's vital that a court look at that as promptly as possible, and we appreciate the efforts the court has gone to get that motion in front of the court. It is essential to the claim for temporary emergency relief that all delay causes increased harm. And so we think it's entirely appropriate that TROs be considered. The court, if it's inclined to transfer venue, can do so after entry of a TRO. The subsequent court can look at that. Obviously, those are temporary, they're interim, and they're intended to prevent imminent and ongoing harm. So additional delay is additional harm, and that's why the court ought to hear the TRO motion regardless of any decision on venue.
Okay, thank you. Mr. Jones?
Thank you, Your Honor. Our position is that the motion to transfer venue is a threshold issue, which Washington courts have consistently held must be dealt with at the earliest stage possible. We have filed a motion to transfer venue as a responsive pleading under Rule 12. No other proceedings have occurred in this case. An inter-superior court transfer would happen efficiently, and there's no reason to believe that the Superior Court of Thurston County couldn't take up plaintiff's TRO motion immediately upon the transfer. That court is, of course, equally well equipped to address the issues raised in the TRO motion. And I'll note that in plaintiff's complaint, most of the harms that are actually specific, that could even arguably make a case for irreparable harm, relate to the Memorial Day weekend, which is long past. Well, I don't know about long past, but it's past. So there's not really an equitable reason that, or any sort of impending emergency that's been alleged or pleaded by plaintiffs that require leapfrogging the logically antecedent motion to transfer venue and addressing the TRO motion first. I'll note that we cited a federal case. I don't think there's any Washington precedent directly on point here, but we did cite a federal case, Northwest Direct Teleservices, Inc., out of the District of Oregon from 2009, where the court did the very thing that we're asking this court to do, addressing first the motion to transfer venue before reaching plaintiff's motion for a preliminary injunction. The court noted that the motion to dismiss for lack of venue needed to be resolved before the motion for preliminary injunction could logically be addressed. Plaintiffs have not cited any case in which a court, federal or state or from another jurisdiction, they've not cited any case in which a court addressed a TRO motion despite a pending motion to change venue. The Minnesota federal case that plaintiffs cite was a different fact pattern. The court had already entered a TRO, and in the interim, the defendant had violated the TRO by continuing its trademark appropriation and unfair practices. And then the court, upon a motion to transfer venue and a motion to extend the TRO, recognized that venue was proper in New York, but given the defendant's willful violations of the court's own order, thought that because of the logistical difficulty of transferring venue from a district court in Minnesota to a district court in New York, that the TRO needed to be extended before, so that it wouldn't expire before the transfer could be facilitated. This case is a completely different situation. The status quo right now is that the governor's proclamation is in full force and effect statewide. And plaintiff's argument that somehow the TRO motion needs to be heard to preserve the status quo simply doesn't make any sense, since the effect of granting their TRO motion would change the status quo.
Okay.
Could I respond to that, Your Honor?
You can, but I have a couple questions first. And I have to admit that there was a lot to read before this hearing, and so I tried my best to read everything, but I didn't have as much time with the pleadings that were just filed. So if I'm asking a question that you've already answered, please bear with me. But
I understand, Your Honor. And I have to say, it was a long reply brief. We had, based on the proceedings in Douglas County, we only had about 4.5 hours to prepare it. So I apologize, to quote, to paraphrase Tolstoy, I apologize for the long brief. I did not have time to write a short one.
That's okay. I just wanted to let you know I might be asking some questions you already answered in there. I did try to read as much as I could, but I didn't get through it all, which I'll have to decide. I probably won't be able to make a decision right away today. I might have to reconvene later today or tomorrow morning to make a decision, just because I do want to have the opportunity to read everything. But I'm going to move forward with the hearing. I'm not, that's not what I'm saying. I just, in terms of making a final decision. My question is and I don't know if it was in your reply brief or your initial brief, you mentioned that the court doesn't have jurisdiction to issue a temporary restraining order if venue is improper. And my question is that really accurate? The court has jurisdiction over any of the cases here in the state of Washington that arise under state law. So it seems that the court would have jurisdiction even if venue is appropriate in another court.
We agree with that, Your Honor. And if the implication from any of our pleadings was that the court lacked jurisdiction, that's incorrect. We did not mean to leave the court with that impression, although for many years there was some uncertainty as to whether this particular venue statute 4.12.020 actually was jurisdictional. The Supreme Court has definitively resolved that it is not. So we agree the court would have jurisdiction, but that doesn't necessarily mean that the court has any obligation or that it's in the best interest of justice to proceed with the TRO motion despite the pending motion for transfer of venue. And I'll note it's not a discretionary standard for the motion to transfer venue. I think this would be a different situation if we recognize that venue were proper in this court, but we're asking, under the 4.12.030 factors, judicial economy, interest of justice, convenience of witnesses to transfer. Instead, because this is a mandatory venue, an exclusive venue statute that vests a right in the defendant to have venue where the cause of action arose, we think that changes the calculus than if this were merely a discretionary decision for the court.
Okay.
But it's not a matter of jurisdiction, Your Honor.
All right, thank you. Mr. Ard?
Thank you, Your Honor. I'd like to address a couple things. One, the state points out that the complaint, which did seek emergency relief before the Memorial Day holiday, focused on the need for that relief over the holiday. Obviously, we had great hopes of getting a hearing before the Memorial Day holiday and appreciate that the court wasn't able to do that until Tuesday afterwards. The fact that we're here now is not through, the subsequent delay is not through any fault of the plaintiffs. And I think it's a little disingenuous for the state to point out that after delay, much of which resulted from decisions the state made, somehow our plaintiffs have stopped being harmed. There is irreparable harm to anyone from impositions on constitutional liberties. Every day that you can't assemble or can't worship or can't freely move about is a harm, and it's a time can't be recovered and run backwards. So the harm, obviously, in the pleadings is ongoing, and every bit of delay increases that harm. And then that I think goes to the merits, as does counsel's comment about the status quo. They utterly misstate the law. The status quo in seeking a TRO is the last peaceable state preceding the current controversy. No one could ever get an injunction against illegal executive action if once the action is signed, that becomes the status quo. I think that statement of the law would come as quite a shock to the Attorney General, who sought innumerable restraining orders against the Trump administration on these very kind of terms, where the chief executive of the federal government issues an executive order that the state believes is improper, and they go seek a TRO to restore the status quo ante, that is the status quo, the last peaceable status preceding the controversy. We're doing exactly the same thing. Upending these proclamations is not a change to the status quo as that's understood in seeking TROs against executive action.
Your Honor, may I be heard briefly?
You may, yes, go ahead.
I just want to point out quickly that plaintiffs themselves delayed a month and a half after the issuance of the stay home proclamation on March 23rd. So this stands in stark contrast and certainly undercuts their claim for the urgency of proceeding immediately. For example, in some of the cases against the federal government that Mr. Ard referred to, of which I was involved in several, and most of those, our actions in federal court were filed on the day or even sometimes before the final rule was issued. Certainly they happened immediately or immediately thereafter due to the impending and irreparable harm that our state would suffer. This case stands in stark contrast where plaintiffs delayed a month and a half before actually filing any of their various lawsuits around the state.
Thank you. And I may have to, there may be occasion where I have to mute myself, and I'll try to remember unmute myself again. I am conducting this hearing from home, so and I did notice, I believe that the plaintiffs filed this case on the Friday before Memorial Day weekend. Is that correct?
That's correct, Your Honor.
Okay, so I do want to hear the motion for temporary restraining order. I have quite a few questions. I am not going to make a decision necessarily. Well, like I said, today, as to either motion, I may be able to make a decision later today if I have the opportunity to review all the briefing that was just filed. Otherwise, it will have to be tomorrow morning. But I'd like to hear the motion for temporary restraining order. I'd also like to hear the motion for transfer of venue, obviously. I'm going to hear the motion for a temporary restraining order first, because if there is an immediate issue that needs to be addressed, I think that I can hear that and address that, and then the motion to transfer venue. Some of the issues are intertwined in these two motions, and so I think it's appropriate to hear both of them. So we'll start first with the temporary restraining order. Mr. Ard, it's your motion, so go ahead. I'm not placing time limits, but I don't want to have to do that. If we start to get too long, then I might have to talk about doing that. But go ahead, Mr. Ard.
I appreciate that, Your Honor. I don't think I have more time than it merits. I'll try to move through it quickly. There's three prongs to show that we're entitled to the emergency relief we seek. It preserves the status quo. I'll address that briefly. We must show irreparable harm, absent the entry of the TRO, a likelihood of success on the merits, and that the balance of equities favors us. In this case, against the governor's official capacity, the opposing party is the public as a whole. Address this briefly, Your Honor. The status quo is not the present proclamation legal regime that we challenge. This is long settled law. A TRO preserves the last actual, peaceable, non-contested condition which preceded the current controversy. That's from Northwest Gas Association from Division 2, 141 Wash App at 115. The non-contested condition is the state of civil governance by the normal organs of Washington government without suspensions of law and new laws pursuant to executive proclamation. And again, the Attorney General relied on that in innumerable challenges. I don't hear them saying that there's any possible dispute to that, merely because the plaintiffs gave the executive some benefit of the doubt in these proclamations before challenging. So irreparable harm. The plaintiffs have ample—
Mr. Ard, I have a question for you though about the status quo, because this isn't a situation, as Mr. Jones stated, and I'm sure he'll probably will hear the reply, but where this has just happened recently. This has been 2 months of the governor's proclamation. And so it's a little bit different situation than something that happened a week or 2 weeks or even a month ago, when we're talking about status quo. And also we've got the situation where some of the things that have been complained about have in part been remedied by very recent orders. And so I guess I just have a question about that. And I'm not faulting anybody for delaying to bring suit, but when we're talking about status quo, does that change anything?
No, it does not, Your Honor. The status quo, again, is not life under emergency proclamations. It's life under the normal status of the operations of civil government in Washington. The fact that any plaintiffs could withstand the severe financial harm imposed on them for a period of time and delayed and waited to bring suit until that harm was almost insurmountable does not change what the status quo is that we seek to preserve. That status quo is the existence of businesses, the right to peaceably assemble, the right to worship. And I would say nothing we've seen from the governor alters that calculus, that minor changes to the executive directions that limit people's freedom of action and freedom of assembly don't change the fact that those are impositions on civil liberties and severely hamper the abilities of the plaintiffs and other people in Chelan County to live, earn, and survive.
Okay, thank you. Go ahead.
And of course, that moves right into irreparable harm. The easiest, and it's shocking in this case that it's less important than other harms, impositions on constitutionally protected liberty always cause irreparable harm. If I can't exercise my religious liberty today, I can never get that lost exercise back. It's the same with assembly and speech. You can never recover missed opportunities to engage in constitutionally protected conduct. So every day of imposition on constitutional liberties creates irreparable harm. But many of the declarations, I think, amply demonstrate that the harm that we're complaining of goes far beyond limitations on constitutional liberty. The damages that go beyond that to people's inability to live and work and earn and feed their families is massive and extraordinary. And much of that will never be recovered. The plaintiffs did wait and give the governor the benefit of the doubt for quite some time, and there are losses that can't be recovered, but every day the proclamations remain in place and continue to bar permissible conduct that would be allowed under guidance from the local health authority, closing businesses, churches, agriculture, and everyday life all over the valley. More and more damage is done. It will be a long road to recovery, but every day of delay makes it longer and harder. So turning to likelihood of success on the merits. I think plaintiffs readily demonstrate they're entitled to relief. There's some points I'd like to make, and I think we can rebut much of what the governor claimed in his opposition. The first one is that the emergency threat to hospitals is over. And so we point primarily to state law. RCW 4306-210 allows the governor to proclaim a state of emergency, but it obliges him, he must terminate that proclamation when the emergency is over. And I'll speak a little bit more to that. The second point is that the presence of a novel virus alone can't be an emergency. I'm surprised that the governor is making this claim about the emergency powers statute. I think it renders it constitutionally suspect if you adopt the governor's claims about it. The governor can't assume emergency powers to address in a different manner a problem that the legislature has already addressed in a comprehensive statutory and regulatory scheme.
Okay, I have a question for you about the emergency, or the, didn't the federal government, though, declare that this was a pandemic and this was a national emergency?
They may well have, Your Honor, but what we're challenging is not whether the governor is piggybacking on someone else's proclamation. His proclamations identify a state of emergency in the state of Washington as an imminent threat to the capacity of the hospital system, the famous curves from the Institute for Health Metrics and Evaluation. The concern was, and no plaintiff challenges this concern, and I think this goes a little bit to the delay that Mr. Jones thinks is so fatal. The initial predictions from the experts at the University of Washington, based on the data we had at the time, suggested that so many people would get so very sick so fast that more people in the state of Washington would need access to hospital beds and ICU space and ventilators than we had space for. And that's a legitimate emergency, a predicted emergency. We also don't contend in any way that the governor needs to wait until the emergency is upon us before proclaiming it. The governor didn't need to wait until the lava was flowing down Mount St. Helens to proclaim an emergency. And we don't contend that the predicted threat to the hospital system was not an emergency or that the governor had to wait. So that accounts for an immense amount of the delay. There appeared to be an actual emergent threat to the capacity of the hospital system. That has undoubtedly passed the governor's own statements, the governor's own experts, the modelers at IHME, the hospital district here, the health directors here, everyone agrees. There is no threat that the hospital system in the state of Washington will be overwhelmed no matter what we do. So the emergency's over. We flattened the curve. The statute under which the governor asserted emergency authority mandates that he release that emergency authority. This is the governor's own words, Your Honor. He said, when he began to allow additional medical procedures, our healthcare system was one of the first in the nation to be hit with COVID cases. When there was much we were still learning about the novel virus. Because of the great work of our healthcare system and communities, we managed the peak of COVID-19 activity in April without having a crisis in our hospitals. What he should have said as the next sentence was that he terminated his proclamations, but because he refused, here we are. And that's a statement he made about a week before we filed suit. Those proclamations identified a threat to the hospital system, and it's over. Chelan Douglas Healthcare System says there's no threat to overwhelming the hospital system in this county. So there's uniform agreement.
Okay, I'm going to stop you there because I noticed something about that I had a question about. The health district did not, nobody from the health district provided a declaration as far as I saw. Did I miss that?
I believe we have, I don't have the entire file in front of me, Your Honor. I believe we do have a statement from an official from the Chelan Douglas Health Director on the official letterhead of the Chelan Douglas Health District.
Right, so it was attached to your declaration, but my concern is if we don't have a declaration from that individual saying I wrote this letter, why is it not improper hearsay? And how can I consider that letter? In addition, how can I consider this the letter from the sheriff and also the draft proposal from the Chelan Health District if it's not attached to a declaration of somebody who has personal knowledge about it?
We could certainly get such declarations and attach them that way. I received the statement from the health director from Douglas County Commissioners. The plan put forward by Chelan Douglas County is the one that was sent to the governor directly, and we can certainly get similar testimony from the sheriff about the authenticity of the letter from him.
Okay, I mean, my concern, of course, with the letters is that they need to be, there need to be attached to a declaration of the person who, I mean, best evidence would be from the person who wrote the letter, but then also with the health district, it looked like it was a draft proposal. I don't have information that that is actually what the health district would implement if the court issued this restraining order. And then my other question is, and of course, you know, being a judge, I can't consider evidence that's not presented in front of me, but I do live in this community and I'm well aware of the fact that we have a very large healthcare organization that is silent in these proceedings, and they are the ones that have the hospital here. And I don't hear anything from them saying that they do have the capacity or that the emergency is over. And so I have that concern as well.
Okay, to speak to those, Your Honor, I think the state's own healthcare dashboard are things of which the court can take judicial notice. Similarly, the county health board has those things. The number of available hospital beds in the hospital district, I think, are matters of public record of which the court can take judicial notice. Happy to provide you after this links to those publicly available government sources for that information. We do know that since the onset of the virus, Chelan County had only 15 total people hospitalized. That was last night's data. Cumulative hospitalizations in total were 15, whereas the healthcare system laid off 1,500 people for lack of capacity when they couldn't do elective medical care. There is certainly capacity to spare, and we can provide, to the extent you think you don't have it, judicially noticeable evidence of that capacity. Again, that just to speak to the healthcare capacity in the state and in the valley.
Okay, and then the other question that I have, because I did, I believe I reviewed all the declarations that the plaintiffs provided, and one of the, I guess, more compelling issues that from the court's perspective is these healthcare issues and the medical issues that have been, that people have been suffering that they couldn't get relief from. It appears, though, that that issue, that emergency, or I guess that's been addressed now because that has opened back up. So I have my question is, are there other healthcare issues that at this point haven't been addressed by the phase 1 changes?
One of the healthcare issues, and it's significant, it's notable, and because of the nature of it, it is very, very difficult to produce the kind of evidence that Your Honor obviously wants and needs and relies on. But simply the threat of increased suicide in the Valley is significant. It's very important. It's something that in the last days and weeks I've heard an enormous amount about. It is very, very difficult to present that evidence. I am open to doing so in a manner that is appropriately respectful of the people who are aware of that and know those who are suffering from it. But it's in the form of information from therapists who can't speak directly to what patients they're seeing and what they're hearing.
Okay, so my question about that, and this kind of goes to other questions that I have a lot of questions for both parties. So the court, and I have, although I'm not in court this week, I have been presiding over quite a bit of the criminal and family law cases and other civil cases. And I do recognize that there is this concern about increased domestic violence and suicide and mental health issues. But first of all, we don't have the statistics. All I can say is that it appears that we do have an increase in the assaultive and domestic violence behaviors, but I statistically, I don't think we have that information as to whether it's an abnormal increase. And then secondly, and if you do have that information or you've provided it, please let me know. But secondly, when it comes to the mental health issues, the suicide rates, the domestic violence, what is it, if the court were to issue this temporary restraining order, how is there any evidence that that would alleviate these problems? Because we still have a pandemic and we still have the need to distance to some degree socially and also in business. And it doesn't look like the health district is saying everything should just open up without any measures. So why is it that the court issuing this temporary restraining order would alleviate those problems?
Both very good questions, and Your Honor, there was one you asked earlier that I started to get to and we moved off track, and I want to address that. And that was the issue of the draft from the Chelan County Health District. They have been meeting regularly to prepare guidance to issue immediately upon receipt of a temporary restraining order. Again, that's there was the document they sent to the governor requesting the shift. I think we have that in the record. And then they have had subsequent meetings about how to move forward. And they're all in draft form because they are not allowed to act. And so what they've done is prepare themselves to act in the event that they're given authorization to meet immediately and issue sort of final regulations for what's going on locally. In terms of what effect that would have on these issues, again, I'm trying to think of the kind of evidence that would be appropriate and that I could present. I think the court can take judicial notice of some materials I could get for you that show a decades-long correlation, well-known, well understood in social science, that a 1% increase in the unemployment rate anywhere in America results as a lagging indicator of a couple of months in a 1% increase in the suicide rate. That kind of correlation is not instantaneous, it's lagging, but it's regular, it's known, it happens everywhere. The most recent data we have as far as the current unemployment in response to emergency proclamations is a study from last week in Northern California that shows seriously spiking suicide rates. I'm not aware of any immediately contemporary studies in the state of Washington, but I am aware of a contemporary study in Northern California and longstanding social science data that shows that. So how would a temporary restraining order alleviate that? The Chelan Douglas County Health District is ready, willing, and able to implement appropriate safety measures as they're required to do under state law to allow businesses to reopen that are currently forbidden from opening. That even yesterday, the executive branch ordered must remain closed at pains of losing their business licenses for life. When those businesses reopen in a safe manner And it will not be a, wild party in the streets like BE Day in Manhattan. When they reopen in a safe manner, people go back to work, people are employed, it immediately begins to alleviate not only the financial harm, the harm to religious liberty and freedom of assembly, but it begins to alleviate kind of psychological harm that is in fact driving deaths of despair here and around the state and around the country. The other thing, are you ready for me to continue, Your Honor?
Yes, go ahead.
It's always hard to tell on digital as opposed to live. The governor is perhaps saying now that this novel virus constitutes an emergency, and that's where, if that claim is upheld, the statute has to fall. The governor can't brush aside a comprehensive statutory and regulatory scheme because he prefers other actions. So what does he have to say about the pandemic flu preparedness and response statute? Well, I would say the text of the statute makes very plain that in 2006, the legislature was concerned with viral pandemics that cause respiratory disease, that spread easily, that appear about every 30 years. In the statute, it says they could kill up to 5,000 people in Washington. If you look at the legislative history, they said it could kill up to 40,000. This is that thing. This is that exact thing. And any dictionary definition of flu includes the common English use of referring to a respiratory disease with these symptoms. It's not even a stretch. We do have the statement very plain that COVID-19 fits that statutory definition. The governor says, well, it's not in the same genus and species as the influenza virus, but that ignores the plain English meaning of the text of the statute. The symptoms of the disease are identical to what English-speaking people the world over refer to as a flu, and it's the very kind of novel disease the legislature anticipated as circling through the world approximately every 30 years. There's no reason. Yes, Your Honor.
So isn't a flu, though, a specific scientific term for a type of virus? An influenza virus.
It has two meanings, Your Honor. It absolutely has two meanings. If you look at any dictionary, it will give you one definition that says it's a virus in this genus and species, and it will give you another definition that says it's an illness with these kinds of symptoms. And I don't think there's any reason that we should look at that statute and think that the legislature was concerned only with viruses that came from a specific Linnaeus classification of genus and species. Another virus arises that spreads in exactly the same manner and causes virtually identical symptoms. And the governor says, well, I should be able to declare an emergency and ignore that statute because in the strictest sense of Linnaeus scientific classification, it's in a different genus and species. The legislature can't possibly have meant to exclude the common meaning of the word flu and exclude a disease that has the same symptoms and has exactly the same public health response. It's not as though this is, an Ebola hemorrhagic fever, which would require a radically different public health response. The public health response to a strict Linnaeus influenza virus is virtually identical to the public health response to this one. So it completely fits within what the legislature instructed the state to prepare for.
Okay, but I mean, this is a virus that we still don't know enough about, and it attacks the body completely differently than influenza. It has similar symptoms, but not all the same symptoms. Some are completely all over the board. I mean, we're talking about influenza has vaccines available. There are so many differences where the scientific term does seem like it is relevant. My other question about this, and I think probably actually the more important one, is this is a preparedness response statute. And why is it that should, is it not that this is to prepare us for these situations? It's a statute to create mechanisms so that we're prepared, but there's a different mechanism when there is an emergent actual pandemic going on.
So I would say a couple things about that, Your Honor. The local health community, first of all, has virtually identical types of responses. If you look at their pandemic flu preparedness and response plan, the local authorities are ready to respond with social distancing, with tracking and tracing, with isolation. So to say this has different treatments in the hospital doesn't mean that it has different public health treatments. And this is not a question of whether when a person who appears in the hospital to be treated what sort of medicines would a treating physician give them. It's what is the public health response. The public health response to COVID-19 is virtually identical in all public health respects, not treatment of an individual patient, but public health respects, to the way you would respond to all the other kinds of viral respiratory diseases recited in the statute as the kind of thing we were preparing for. In terms of it being preparedness and response, that's absolutely correct. The legislature explicitly said that when this kind of thing arises, here's what the state response will be. And it will involve local authorities as the first one. Local authorities take over and do what they prepared to do and respond the way they were elected and hired and prepared to respond, with response plans that have been approved annually or biannually by the State Department of Health. Again, if the governor can say, this is a different species, or I simply don't like the response that state law and the county health departments and the Department of Health were ready to do, and therefore it's an emergency, he could do that for practically any statute. And there's no way the legislature, in giving him this limited authorization to proclaim an emergency and vast powers behind that proclamation, there's no way the legislature intended to give him the authority to simply look at existing statutes and existing regulatory regimes and say, I don't like them, I'm writing a new one. I mean, another one of the claims the governor makes is that he should be allowed to disregard the statute because COVID-19 is more lethal than SARS. I think this goes to a certain extent to the same points Your Honor was just raising. It's not relevant. How you treat it is certainly not relevant. Second of all, of the many things we know about COVID-19, and there are certainly unknowns as there are with any novel virus, just yesterday or the day before, the CDC came out with a conclusion that it's vastly less lethal than SARS. Neither one of those is important, whether it's slightly more, slightly less, 1/10 is not. The important point is that it fits within the legislature's prediction of what they intended local government to respond to. They wanted local government to be the first line of response for a novel virus that's respiratory, that spreads easily person to person, and could kill up to 5,000 people in the state of Washington. At the height of the predictions from IHME, they predicted that this virus could kill as many as about 3,250 people. It's well within the bound of what the legislature decided should be addressed in the first instance by local government. Of course, the predictions now are far below that. Thank God, it's great news that it was not as bad as we feared. It's certainly not as bad as we planned for. It's not as bad as the Grand Douglas County Health Board is ready to respond to. If this is nothing more than a neat idea of something we ought to look at, but then the governor can do something else, it's as though the legislature built a fire extinguisher box on the wall and put a styrofoam model in. That's certainly not what the Chelan County Health District thinks they did. They believe that they have a plan to respond to the problem. They believe they're ready, willing, and able to respond. It's what the statute calls for. The governor also argues that the flu pandemic statute, coming later in time, did not repeal the emergency authorization statute. Well, that's true, but irrelevant. There's been plenty of laws passed since the emergency authorization statute was passed, and it makes no difference which one was passed first. Again, if that position is adopted, it renders the authorization statute unconstitutional. If the governor can simply decide that he prefers his responses, which are every day drafted and enforced as law under emergency proclamations, instead of the governing response required by existing law, he can maintain emergencies for any reason he pleases. And this is ultimately the governor's good faith position. With a governing statute on the books, the governor can't simply decide he prefers not to and displace the legislature and displace local officials by emergency proclamation. And when he argues that as long as he thinks in good faith that something's an emergency, then that's the end of the inquiry. If the court adopts that interpretation, it renders the statute unconstitutional. That can't possibly be a proper reading. The governor is definitely entitled to a significant degree of deference about how he decides to respond to an emergency, but not about whether it actually is an emergency. I'll give you an example, Your Honor. Washington unfortunately sees around 500 fatal car accidents a year. We have a comprehensive statutory and regulatory scheme governing traffic with the intent of reducing the number. It's not perfect, but the governor can't decide that he finds 500 accidents an emergency and by proclamation ban non-essential driving and have the governor define what's essential. There's no good faith review to judicial review of that decision by the governor. Courts do defer, absolutely, to issues outside the core competence of the judicial function and where executive or legislative discretion is appropriate. So what should we do in response to an emergency? That's not the case here. It is completely within the core competence of this court to examine the facts of the asserted emergency, find out, do those facts still exist? That is to say, the healthcare capacity, or look over the revised Code of Washington and determine whether the underlying fact situation claimed by the governor to be an emergency is actually a situation covered by existing law. Obviously, it's not the case that there's no problem left in the state of Washington. The question is the problem faced by the state of Washington a problem for which existing statutes provide a solution? If the claim by the governor that there is, in fact, an emergency is not subject to judicial review, if the courts allow the governor to proclaim an emergency for anything, as long as he says that he's acting in good faith, if he can set aside existing statutes to claim an emergency over something the legislature has spoken to, the statute is constitutionally void. It violates, certainly, Article 2 of the state constitution, which gives legislative power to the legislature. The legislature can't give that away to the governor and did not intend to in this statute. The governor can't take it from the legislature, and he can't avoid meaningful, searching judicial review, which is well within the court's fundamental competency on both counts. Is the unexpected, unusual, unprovided for event over? Is there still an emergency? And second, is the thing he calls an emergency actually governed by existing statutes? If there's no judicial review of those questions, the statute is subject to grave constitutional doubt.
Okay, so I have a question for you about this too. I mean, this is just, as we all know, this is unprecedented. We are 2 months into this, and I do have, I mean, there are questions about at what point has an emergency gone on too long, but isn't this something that's more appropriate to be addressed by the state legislature? And most certainly, in the amount of time that we're looking at, the state legislature, if what has happened is not in line with what the legislature intended, then why would the legislature not step in at this point? Why is it, it seems to be outside of the bounds of the court's authority to step in when the legislature has spoken to these issues and is also has the ability and the time to say what the governor is doing is not appropriate under the statutes or change the statutes, and that hasn't happened.
Your Honor, it is absolutely within this court's authority at a moment when we have two statutes on the books. We have an emergency authorization statute that requires a proclamation to be voided when the emergency is over. And we have another statute governing what the governor now claims is an emergency. It's absolutely within the court's competence to make that review. Why is the legislature not in session? Well, the session ended when there appeared to be an actual emergency. And no plaintiff, no one I know is questioning that the predictions of IHME at the outset of this problem did present a circumstance where the governor was within his authority to assert an emergency. But the legislature's out of session. The governor hasn't called them into session, and they have not, by the required supermajorities of both chambers, called themselves back into session. Should they? That's outside my competency, my plaintiff's competency, and I think it's outside the competency of the courts or the attorney general. Truly a political question of whether or not the legislature should be in session right now. But the question that's left is a pure question of fact and law. What are the facts on the ground? Is there an emergent threat to the hospital system? What is the thing the governor asserts as an emergency? And is it addressed by existing law that requires the Chelan Douglas County Health District in the first instance to take over public health in Chelan County? Those things are absolutely within the court's core competency, and absent legislative action anytime in the last 10 weeks to change the governing statutes, what plaintiffs are left with for due review of these claims is recourse to the courts. If the legislature comes into session tomorrow and alters these statutes, I'm quite confident I have to take a close look at them and decide whether my claims had been mooted by a change to the statutes. But as long as they're the statutes on the books, we and you have this venue to hear those claims heard. That's as much as I have to say about why we will succeed on the merits. I can say a few words about balance of harm if you're ready.
Yes, go ahead.
Thank you very much. Obviously, we've discussed at great length the harm to the plaintiffs discussed in the declarations. For a TRO against the governor acting in his official capacity, the other side of the ledger is harm to the public. And that can't be measured as a question of whether anyone ever will get diagnosed with COVID or even hospitalized. The governor himself asserts that that will continue to happen. Everyone's agreed that this virus is now part of the population, referring to the new normal. It's out there, people will get it. The question is not whether anyone will ever get infected with the virus. The question is whether the Chelan County Douglas health authorities are ready, willing, able, and competent to address the issues and infections as they arise. Do we have to live under emergency proclamations in order to have an appropriate response to the possibility of infections and treating those in our community who are, in fact, infected by it? And the answer clearly to that is no. The governor can't possibly demonstrate that the Chelan County Douglas Health Board and local health authorities are not capable of dealing with infections from this virus as they arise. That is, in fact, what they have routinely done. As they've seen about 300 infections, they've done routine tracking and tracing. They've gone out and visited people in communities where infections arise. They've got fantastic treatment protocols in the hospitals. They've had 15 people hospitalized. They know how to deal with the problem when it's here. They know how to relax restrictions in areas where there's not infection. They know how to tighten restrictions in areas where they are. That's what their job is under state law, and all we need is for them to do it. But the governor simply can't show that health outcomes in Chelan Douglas County will be worse if the Chelan Douglas County Health District is given the reins in responding to health problems in Chelan County. That's the hurdle they would have to show to indicate that there is more harm from issuing the TRO, because the change to governing law would be, instead of emergency proclamation, a restoration of appropriate legal status quo, which is governed by the Chelan County Health Board in Chelan County.
I muted myself. I will ask, I will want the Attorney General's office to address that issue. But again, I go back to my question about whether this, the health district taking over is going to alleviate the harms that have been stated by the plaintiffs, because many of the harms that have been stated by the plaintiffs are absolutely concerns that and harms that most people in our community have been suffering in one way or the other. And I just am not sure that some of these will be alleviated by the health district taking over, because it's by virtue of the fact that we have this pandemic and this virus that, for example, some of the concerns about not being able to see people who are in hospice care or who are in other facilities, those are often private facilities, and they will have their own rules and regulations, and they have liability that they have to address. The health district taking over isn't necessarily going to change that. And also in terms of not being able, grandparents not being able to see grandkids, again, it's something that many people are suffering from, and not to diminish it at all, but it's just, I'm not sure that that harm is going to be alleviated by the health district taking over. And
Right.
So those are the concerns that I have.
I appreciate that, and I think we can say with confidence, and again, to whatever extent Your Honor thinks that the evidence we assembled as we were preparing to file needs to be augmented, we can do that. The clear statement in there from the Chelan County Douglas Health Board is that given the opportunity to fulfill their statutory obligation and follow the pandemic flu preparedness and response plan that they have in place. And again, Your Honor is correct, those are marked as draft. They don't intend to finalize them until they have legal authority to finalize them because they're no longer operating under proclamation. They say very clearly they would impose fewer restrictions than the governor imposes. Is it a complete, absolute U-turn 180, every past harm and future harm is completely alleviated and remedied instantly? Of course not. We recognize that some of the harms that have taken place will be remedied very slowly, if ever, but many of the harms will be alleviated immediately because there will be fewer restrictions imposed by local authority. And again, it doesn't have to be perfect. We know that there, in fact, is a novel infectious disease in this community, as there is everywhere around the state and the world. But the Chelan County Douglas Health Board says we have the legal right, the legal obligation, and the absolute ability to address this. And if and when we address it, we will do it in a manner that imposes fewer restrictions on these plaintiffs. And that is an immediate benefit and an immediate reduction, at least, in the harm that they're suffering.
Go ahead.
I was done.
Oh, sorry. I didn't know if you had more that you were planning on arguing this to the TRO.
No, as to the TRO, Your Honor, again, irreparable harm, success on the merits, and no possible showing of public harm by the governor, because it's simply impossible for him to demonstrate that local health authorities will do a worse job taking care of local health than will living under proclamations from Olympia. The emergency is passed, and civil government in Chelan County should be restored. Thank you.
Okay, thank you. Mr. Evan, is it Evan or Even?
It's Even, Your Honor.
Okay, Mr. Even, go ahead.
I'll note that over my life, almost nobody gets it right the first time.
Okay.
I'd like to begin perhaps just by responding to the last comment of Mr. Ard, which seems to misconstrue where the burden lies in this case. Mr. Ard makes an argument here that the emergency is over, and by the way, I'll note that's inherently inconsistent with his argument that the governor didn't have authority to enter emergency proclamations at all because another statute, he says, has superseded it. But setting that point aside just for a moment, the question is not whether the governor can prove that there would be a better outcome if the TRO were granted than under his proclamation. Rather, the question is whether he's shown a substantial likelihood of prevailing on the merits of this case. And the factual and legal burdens that are attendant on that rest with the plaintiffs, not with the governor. Now, beyond that, where I intended to begin this morning was to note that rather than, I guess, organizing my thinking about this in terms of the elements of a TRO, I think we have 4 different conceptual points that have become relevant to the discussion today that parties have emphasized. The first of this, and I'll just give a roadmap here of where I'm headed, but my real agenda is that I want to respond to what the court is concerned about hearing from the governor about. The first of these is the legal point of whether Mr. Ard is correct that RCW 70.26 deprives the governor of the authority to issue statewide proclamations that's granted to the governor under RCW 4306-220. Mr. Ard's argument in this regard is essentially that the legislature has determined that there cannot be an organized statewide response to a global pandemic emergency, which is frankly absurd, both as a matter of public policy and as a matter of reading the statutes themselves. The second is, and perhaps this goes in some regard to the point that I began with, the factual development. The governor issued the series of proclamations that he has issued based on science, epidemiology, data, expert opinion. The record includes as attachments to the declaration of Mr. Jones, a declaration by David Postman that appends the various proclamations that were issued up to the point of that declaration. And it includes a declaration from the state's chief health officer, Dr. Kathy Lofi, regarding the epidemiological reasons for entering into these proclamations. So against which the plaintiffs have not offered any expert testimony. They have offered the observation that hospital capacity is not currently an issue in Chelan County, but of course, this is presented in a context of kind of a lot of people are saying, as opposed to here's direct admissible evidence of something that I want the court to accept. The final two, and I think these all to some extent interrelate, that I've jotted down in notes today. One I have under just the general heading of status quo. And the related one is redressability. So what I think I'd like to do is move from, is to talk first about the issue of law. Does RCW 7026 supersede the governor's emergency authority without ever saying so? And then, of course, I'll invite the court to interrupt at any point. RCW 7026 is a statute, as the court already indicated, that goes to preparedness for dealing with flu outbreaks. What it's attempting to do, what its objective is to require the local health departments throughout the state to have plans in place to address a flu epidemic that could come about at any time. It's not about superseding any other authority. It's, of course, the anticipation would be that when an epidemic strikes, the local authorities would then act according to their plan, but that's the purpose of having a plan. It is not to suggest that a problem that is of statewide significance, in this case, in fact, global significance, is actually superseded and must be dealt with piecemeal, county by county across the state. RCW 4306-220, and I'd like to look at the language of this one just a little bit, authorizes the governor general authority to deal with statewide emergencies, realizing, of course, that in drafting the statute, the legislature doesn't know what the emergency is going to be. It's drafted to deal with a contingency that probably, as the legislature drafted this, hoped that they would never actually see. But it gives the governor two different kinds of authority. The first is, this is RCW 4306-220 sub 1, the governor, after proclaiming a state of emergency and prior to terminating such, may, in the area described by the proclamation, issue an order prohibiting, and then there's a list of various things. The proclamations that are issued in this case are issued under the authority of paragraph H in that list. Such other activities as he or she reasonably believes should be prohibited to help preserve and maintain life, health, property, or the public peace. So there is a significant measure of discretion here granted to the governor as to what prohibitions are necessary for that purpose. And I want to talk about the application of that here too, but first to note the other kind of proclamation the governor can issue, which is about, this is under sub 2 of the same statute, allowing the governor to suspend statutory and regulatory obligations that would otherwise be applicable. So for example, early on in this discussion, when there were kind of ad hoc hospital facilities getting set up in like Questfield in Seattle, and there, in order to set up a medical facility in general, a hospital would have to go get a certificate of need from the State Department of Health. Well, in an emergency, that's inconsistent with dealing with the emergency. So that's an example of where suspending statutory requirement was part of the response. And that's important here because those kinds of proclamations are limited to 30 days unless the legislature extends them. And the statute does provide a mechanism by which the legislature can do that when it's not in session. And the legislature has consistently been extending most of those proclamations as time has gone on. Not all of them. So there is significant review going on here from the legislature. But at no point in any of that has the legislature come back here and said, Governor, your emergency is over. It's time for you to stop. That simply has not happened. Now,
I have a question about that. So is it your position then that that's really the appropriate course of action here if the governor was exceeding the authority in the statute, is that the legislature would need to step in?
I think that's certainly an option the legislature has. Now, the point that I just made has to do with not extending proclamations that suspend legal obligations. The legislature does also have the constitutional authority to call itself back into special session. The governor can call them into special session, or they can call themselves into special session. And so, yes, if the legislature wanted to address that problem, or if they perceived it as a problem, they certainly could do so. Now, that takes me, I think, to a point about how the governor has exercised this discretion. The governor's done so consistently based on changing and evolving scientific and epidemiological evidence. That's in the record in the form of the declaration from Dr. Kathy Lofi. In no instance is that scientific and epidemiological evidence confined to the single metric that plaintiffs would like it to be of hospital capacity. The expert view is that even if hospital capacity is not an immediate problem, the virus remains highly contagious. And if the restrictions that are entered into under the governor's various proclamations are not carefully handled, and that there isn't a careful unwinding of those restrictions, we could easily have a bounce back. One of the reports, and here I'll say this is not in the record, it is available on the governor's website, indicates that as of a couple of weeks ago, the state of Washington remained on a knife's edge, was the phrase from the epidemiological modelers, that if we handle this carefully, we could be through this and be done. If we recklessly reopen, then we have a problem. Now, and the governor has exercised discretion about that and has introduced geographical nuance on that. So, I think if we had an emergency that was very limited to a particular geographic area and nonetheless tried to have a one-size-fits-all approach, there could be concerns about that. That's not the case as the governor's gone forward. We see that 24 counties, I think at this point, have advanced to phase 2 of the governor's reopening.
Okay, so I have a question about that. It appears that large factor, the primary factor that the governor is looking at in terms of reopening or going on to phase 2 has to do with the number of positive cases, the increase of positive cases in a county. King County and Chelan County are very different, and I don't see anywhere in the materials that there's been any consideration taken into the fact that many of the positive cases may have been, and again, unfortunately, living in the community, I'm aware that there are more sweeping testing happening of certain facilities, and asymptomatic cases testing positive. It seems to discourage testing to say that if somebody tests positive, that's going to decrease the county's opportunity to go on to phase 2, when we're not actually looking at hospital capacity, hospitalizations, symptomatic cases. We're only looking at positive test results. So has that been, I don't see in the materials that that's been factored in when you're talking about a rural county, when you have a, I guess, an outbreak in a facility that's perhaps separate from a town or city, is very different from having an outbreak in an area that's a sprawling urban setting. Do you have information about whether that's been taken into consideration?
I don't know. I can't answer the question very specifically, but I can say this. First, I can offer the observation that among the very first outbreaks that we had in the state was exactly that kind of an outbreak occurring in King County in a retirement facility. So the fact that that's a driver, and that's a place where the virus can spread very quickly if it's introduced, is definitely a consideration. In that regard, one of the things we did note in our response to the motion was that as of the time we filed it, Chelan County ranked number 5 out of 39 counties in the state in the number of new cases arising within the prior 2 weeks on a per capita basis per 100,000 population.
Okay, but the question is that not because there was a large testing of groups of people that were asymptomatic? It was really a precautionary measure to understand how many cases we have. And so because we took those precautionary measures, now we have this increase in cases. They weren't symptomatic necessarily, but now it impacts our ability to move on to phase 2. And again, it seems to discourage large scale testing, because if people are tested and they're asymptomatic, they're still going to count towards the total numbers of increased positives.
I'd have several points, I guess, to make in response to that. One is that a person who is asymptomatic but tests positive nevertheless can be a source of spread within the community. And our objective is not to make the number of positive tests drop to 0. It's to control the spread of the virus. So the testing is not, the testing results themselves are not the objective. We could make all the positive test results go away by not testing anybody. But beyond that, I'd offer the example of what's happened in Kittitas County. When the governor initially provided the opportunity for a number of counties, number of smaller counties to apply to go to phase 2, Kittitas County qualified as one that could have that, or that could make that advance. That was suspended, and something like this is currently happening now in Clark County, where there was an outbreak in a particular facility. The opportunity to move to phase 2 was not denied to Kittitas County. It was frankly suspended. Kittitas now has moved to phase 2. Clark County is a little earlier in that process. They met the qualifications otherwise to move to phase 2, but because of a specific outbreak in a facility there, that application is on hold. And the hope is that once that's under control, and this measure of the degree of risk of moving to moving to phase 2 may diminish there, then Clark can also move to phase 2. So yes, there is this so the geography is considered in that sense, in that we're looking county by county at what is to happen. But maybe a bigger point related to that, and this kind of jumps into my point that I guess I'll call redressability. I'm not really arguing standing here, but I'm arguing whether issuing a TRO would actually have the effect of remedying the harm that the plaintiffs contend. They're arguing somewhat inconsistently here. To some extent, plaintiffs are arguing the governor can't continue with his emergency proclamation because they say the emergency is over. Well, if they had actual evidence, if they actually produced expert testimony to say, you know, what's happened here is the governor just decided he liked governing by proclamations too much, and even though the emergency's gone away, he wants to continue, that would be a very different case. And a plaintiff in a case like that might have a remedy. But this is not such a case. This is a case in which the governor has relied on science, data, and epidemiology, and has exercised the discretion granted to him by law in a way that these plaintiffs, for perfectly understandable reasons, are uncomfortable with, don't like. But if that order is removed, we don't really know what the result of that would be. We have, you know, statements from the county health, the bi-county health department, that they'd be ready to deal with that. But really, in arguing that point, all Mr. Ard is saying is that regulation ought to be done locally, not by the state. But on the other hand, he's making the very inconsistent argument that there can't be a response to the pandemic at all, because he says the emergency is over, and we're to trust that, not the science and the data that the governor has before him and on which the governor relies. That is quite a stretch. Now, and to return a little bit to the point about Chelan County in particular, in our response to the motion, we pointed out that Chelan at that point was number 5 in new instances among the states, among the counties within a 2-week period. I asked for an update of that information before the hearing this morning, and the circumstance now is that conditions in Chelan County have actually deteriorated. Chelan County is now number 2 in the state for the rapid spread of the COVID-19 virus, behind only Yakima County, where there is a major outbreak. It's one of the hotspots in the Western United States right now. So the data, if we were going to pick a county to say the governor's being arbitrary and holding a county to a higher standard than they should be, Chelan County is not the one that one might tactically pick for that.
I guess, I mean, and that's the issue that I have with that, is those numbers somewhat appear to be based on large scale testing of employees for no reason other than to know whether they are positive or not. But is that happening in other counties? Is that something that just because we have employers that are being proactive here, that then that Chelan County is not allowed to move on to phase 2 because we have proactive employers here?
No, testing is a statewide concern. In fact, the governor has stressed that one of the conditions for being able to move forward to the higher phases in the reopening plan is the availability of widespread testing, so that, you know, early on, I think I draw this contrast. Early on, testing was very restricted, very limited, and was pretty much happening only with individuals who were presenting with symptoms, and in the very early stages, maybe not even then. So in order to be able to reopen the state, we have to know to what extent the virus is spreading in a community, not strictly how many tests are we getting within a limited population. Widespread testing everywhere is a key that the governor has stressed in his discussions about moving to his higher phases. So retesting and then contact tracing, so that we can, if there is, you know, to the extent there continue to be new cases, and there will be, we can trace those contacts and try to prevent the community spread. So widespread testing is it isn't just an aberration in one place, it's a priority of the entire plan for reopening the state.
But our testing requirements and availability of testing, is that not different from county to county?
I can't say that it is or that it isn't. I don't know about the availability. I can say that it is a priority everywhere. So, you know, I suppose what this might get us to is kind of what's the analysis that a court would use if, in considering a challenge to the governor's emergency proclamation. Mr. Ard seems to say, well, no, there is no mechanism. The governor is just saying he's the final word. I think if we had actual evidence, and this is the thing Mr. Ard is missing, the governor has exercised his discretion to issue proclamations to protect the lives and health of the people of the state of Washington. Mr. Ard thinks he's wrong. If Mr. Ard could produce evidence that what the governor says is necessary is not necessary, he would be able to present a claim and perhaps, if the evidence is convincing, perhaps even have merit. But simply saying the governor has done this, I have concerns that the governor has done this, it has caused harm, and that's true. There are burdens, obviously. That's not enough. That's misconstruing who has the burden of going forward in this case, who has the burden of proof, who has the burden of convincing. But again, I keep coming back to the inherent inconsistency in Mr. Ard's position, which seems to be, on the one hand, the governor had no authority to issue a proclamation. On the other hand, he had authority to issue a proclamation at first, but it's no longer justified. I don't have any evidence of that, but it's no longer justified. We should set it aside. That's where we are. And that's not a legal or factual environment in which the governor's exercise of his emergency authority is subject to challenge.
So I have, and the reason I'm asking about maybe seem issues that these do relate to how I look at this from the legal perspective, because I think that what Mr. Ard is saying is there was an emergency and now there isn't. He's provided some evidence, although I explained that I have some concerns about providing declarations as opposed to attachments to his declaration. And I will allow him time to do that. But if you could, and I know the materials are voluminous, but if you could direct me to where in the materials, and I am not minimizing the seriousness of the pandemic in any way, but looking at this from a legal perspective, where in the materials that the state's provided is that there is a current emergency.
Well, there in the materials, we cite to well, in fact, I think in our TRO response, there's a graph that's shown. That graph links to a website of the Department of Health, which is updated weekly. And looking at what that shows now, this is the Department of Health statewide dashboard. They include testing results by county. And what they currently show is that in Chelan and Douglas counties, the rate of tests that are positive, so that's, however many tests are being conducted, what percentage of these come back as a positive test. Right now, Chelan County has a positive test rate of 9.9%. Douglas County next door has a rate of 14.3% of their tests are positive. The statewide average, the statewide results are 6.1%, and in King County, they're 8%. So what the data shows is not that the number of positive tests coming back in Chelan County is because of an unusually high number of tests. It's because a higher number of the tests that are conducted come back positive. So the data doesn't support an inference that somehow conditions are better in Chelan County and the governor simply isn't recognizing those conditions. So I think that's my factual answer for that.
Okay, I mean, but I do think hospitalizations and how this is affecting the community is important when we're talking about a health emergency, and I'm wondering about that information. because
Well,
the
and
plaintiffs are saying that currently it's not an issue here. And it may be that it isn't currently, but it will be because this virus has a extended time frame of affecting people. But I'm just wondering about that information.
that latter point is a very important one. The same dashboard that I pointed to also has county by county data on hospitalizations and on deaths, by the way. So all that data is up there. But I think it's the wrong inquiry for this court to attempt to micromanage the emergency response of the governor with a statewide emergency. So,
well, that's not what the court's, the question is, and the plaintiffs opposed, is there even an emergency? And one of the questions that I have is, how long does an emergency last? I mean, at some point, is it something different than an emergency if it's lasted for too long?
If it's,
this appears to be a question that the plaintiffs are posing as well.
Well, emergencies are not time limited. Emergencies are fact and circumstance limited. And so again, that comes back to the total abject failure of the plaintiffs to produce actual scientific and epidemiological expertise or data to show that the governor is wrong. The burden rests with them. The governor's declaration of an emergency statewide is entitled to deference until such time as it can be shown that it's simply arbitrary and without factual support. Nobody claims that it could be perpetual, but it does last as long as the facts last, and it lasts as long as as there's been a failure of proof to show that the facts have changed. Now, that I would note, by the way, in that regard, there was an earlier discussion about what's the flu and is COVID the flu and how do we define the flu? As a matter of statutory construction, in Washington, the law is that the first and foremost element of a rule of, the first and most elementary rule of statutory construction is that it's assumed that the words and phrases in a statute are used in their technical meaning if they have acquired one, and in their popular meaning if they have not. That's State versus Tiffany, 44 Washington at page 603, an admittedly old case, but I think under that provision, if we're looking at is COVID-19 the flu? Ultimately, I think that's an irrelevant question, but the question is technically, is it? No, as we've shown in our materials. And that, I hate to belabor this point, but if Mr. Ard's argument is that the governor has no authority to address a statewide emergency under 4306-220 because of 7026, there's no support in the text of that statute to in any way limit the governor's authority, and we are not in a position of needing to say, well, we default to local authority. We get to have a piecemeal situation in which counties, counties adjoin each other. People from one county travel to another county. If they're carrying the virus knowingly or not, they're carrying it with them. But nevertheless, plaintiff's position seems to be we cannot have a coordinated statewide response. And they have offered nothing to indicate that under any scientific or epidemiological opinion, that emergency is now over, and we can simply say there's no longer a basis for a statewide response.
I do want to point out that I don't think they're saying there wasn't ever an emergency and the governor didn't have authority. I think that what plaintiffs are arguing is that there isn't currently an emergency. And so because there isn't, then the RCW 70, and now I'm 0.26 kicks into action, if I remember correct, if I'm understanding correctly their argument.
Well, and there would be no textual support. I mean, I have heard Mr. Ard say that he thinks the governor initially had the authority to declare an emergency. But that's completely inconsistent with his argument about 7026, because that statute either applies or it doesn't apply. It's not something, there's no mechanism in that statute or in any statute to say, well, you know, when such and such a thing happens, the governor's authority goes away. Well, it would go away, I think. You know, the RCW 4306-220 does say that the governor's proclamation authority lasts only until the emergency is terminated. It is for the governor in the first instance to exercise his discretion to decide whether the emergency has or has not been terminated. If the governor says it has not been, and Mr. Ard believes it has been, Mr. Ard needs to go find himself an expert witness and convince a court in the proper venue that the actual evidence supports what he thinks the facts are. That's a question of who bears the burden. As to substantial harm, I think the balance of harm and equities, I'd like to address that just very briefly, that the evidence presented by Mr. Ard, the competent admissible evidence, addresses only the harms that are suffered by his clients. These are admittedly significant, but the analysis does not end there. The governor's larger concern is how to control a highly contagious virus that, you know, remember, we go back to January, we had what was at that time believed to be the first case in the United States of COVID-19 in the state of Washington. We went from one case to thousands of cases. And so the issue is not simply, oh, there's hospital capacity right now, or the health department thinks they know what they're doing. They probably do. The health department thinks they know what they're doing. The question is, in balancing the equities, to look at the governor's interest in protecting the lives and health of all the people across the state. That decision is approached based on scientific and epidemiological data and opinion and analysis. It's not based on anything we have here today. So in balancing the harm for the entire state weighs very heavily in the governor's favor in the balancing of the equities on the issuance of a TRO. If the court has further questions, I'm happy to, I should clarify one thing. I said earlier, I think that hospitalization data that the court asked about is also on that same Department of Health dashboard. I'm not sure if it is. There is data there about hospitalization, but and I believe it's broken down by county, but I'm not completely sure of that. So I want to take a half step back from what I represented there.
I'm going to say I don't think that when I looked at it, it was broken down by county. So I mean, again, that goes to the court's main concern is just that what is the situation here in the county, and is that some sort of a basis to establish there isn't an emergency? I mean, Washington is a diverse state, both for a variety of reasons, and we've got rural counties and we have urban counties, and it looks like the governor has addressed that to some degree, but also there's concern that some of the counties are being treated the same as the urban counties, and isn't it, if it's an emergency in one county, is it an emergency across the state or not?
Well, the emergency statutes do allow the governor to declare an emergency in only parts of the state. It doesn't have to be one size fits all, and of course it currently isn't. But I don't think the distinction that it's not fair to say that the distinction is urban-rural so much as it is where is the virus spreading. I'd look at Yakima County as a big example of that. Yakima County is one of the hotspots in the Western United States right now because of outbreak there. So, and people, as I point out, people travel from one state to another. These are matters that the governor can address within his discretion and is addressing within his discretion. But to say that there's evidence before the court right now, or even within the judicial knowledge of the court, to suggest that there's a basis for saying, no, Governor, there's no emergency in Chelan County, that's completely lacking and unsupported by anything that Mr. Ard has put into the record in this case. Unless there are further questions, I'll suggest that the balance of equities and the likelihood of success on the merits both very strongly dictate that this court should deny the motion for temporary restraining order.
Okay, thank you very much. Mr. Ard?
Yes, thank you very much, Your Honor. Mr. Evans suggests repeatedly that I've been inconsistent. I think Your Honor has correctly identified that's not so. And Mr. Even again focused to great extent on the scope of the governor's authority and discretion under 4306-220. I don't disagree. He said that I haven't presented evidence that there's not an emergency. That's right, he has. His evidence shows that. We are relying entirely and completely on the governor's own statements and the text of two statutes. And the first one's not 220, it's 210. When can the governor proclaim an emergency, and when must he terminate it? When must he terminate it? He can proclaim it just about any time when he says there's an emergency, but he must terminate it when order has been restored. And so this is why we're looking both at 210 and at the pandemic flu statute. And our position is, of course, that the pandemic flu statute and those pandemic preparedness plans do not, as far as anyone can tell, we make no claim that they do this, they do not address the possibility of the entire state hospital system being overrun with patients. And that was a legitimate emergency unprovided for by any statute that we can identify. We have no doubt that faced with the distinct possibility that there would be more people in need of hospital beds than beds available, the governor was within his authority to declare an emergency. But when that situation passes, 4306-210 says the governor must terminate said state of emergency proclamation. We all know from the governor's own evidence that situation is passed. IHME models say that. All the evidence that the governor put in says that. There is no threat that the state hospital system will be overwhelmed such that beds will not be available. Does that mean there's no problem in the state anywhere? Absolutely not. We know perfectly well that this virus is present and capable of spreading. But that can't be an emergency that displaces existing law. To use a simple example, if a tidal wave is crashing across the Pacific towards the west coast counties of the Olympic Peninsula, the governor can declare a state of emergency. But when the tidal wave subsides, he can't maintain the state of emergency on the grounds that he's concerned about beach erosion. Beach erosion is a chronic problem, and we have plenty of statutory and regulatory regimes to address how Washingtonians care for their environment at the waterfront. We have a comprehensive statutory and regulatory scheme. Mr. Even repeatedly suggests that I'm claiming we shouldn't have a statewide response to this. Not true at all. The pandemic flu preparedness and response statutes is a statewide response. It provides first line of authority in the local health districts. They coordinate with the Department of Health. The Department of Health has repeatedly approved these plans over the course of 14 years. So what Mr. Even is now claiming is the very thing that would render the emergency authorization statute unconstitutional. An existing statutory and regulatory scheme, statewide problem or not, it's an existing statutory and regulatory scheme to address a problem faced by the people of the state of Washington, established by the legislature. It has full force of law. It covers every issue he's identified. Look at every single piece of expert evidence they put in, and you will find that they are discussing a problem that exactly fits within the scope of the problem the legislature addressed in the flu pandemic preparedness and response plan. What the governor has just told you is that he intends to displace existing statute in order to address a problem that is completely covered by that existing law. The legislature in the emergency authorization statute, 4306-210, could not possibly have given the governor the authority to decide to rewrite statutes. If the existing statutory response is inadequate, the governor does in fact need to call the legislature into special session and get new statutory authorization to address a problem that we absolutely recognize continues to exist in the state. What we say is, you can't call it an emergency because you don't like existing law. And that's what they've done. Threat to overrun the hospital system, no existing law, emergency. When that threat fades, 210 says you must terminate it, and let's go back to existing law and see how we address that problem. If there was no law to address this sort of problem, I might concede that it can continue to be an emergency for long periods of time, but there is a law. It does have a coordinated statewide response. The difference is in the first line, it's in the local authorities' hands. Mr. Even suggests that I can't possibly show that the balance of harm favors my clients. It absolutely does. It's the governor who can't show why he isn't following the existing statute. Is he ignoring 70.26 because it only applies to a specific genus and species of virus? Is he making use of all the preparations and resources that address other emergencies in subsection 6 of that statute? If he's making use of the flu pandemic preparations, why does he never talk about it? Everyone was ready to respond to this. It exists there, and he has a burden. If he says, this is such an emergency, despite the existence of the statute, this is an emergency that allows me to act differently than statutory law, it absolutely must be his burden to show that the existing statute is inadequate to the task. And he makes no attempt to do that. From all the data they provide, from everything we see on the dashboards, from everything we see from the State Department of Health and all the experts they put in, this problem facing the state is exactly within the scope of a statute the legislature already created. And they can't show that displacing that statute is necessary to protect the health of all Washingtonians. 37 different local and county health districts have the tools available to address this very kind of problem. And there's no demonstration by the government that the problem is so unusually different or severe that the existing statutory regime can't address it. So when Mr. Even says that I didn't produce an expert and have to, I would say all I have to do is read the experts he brought in. What they have said is, unprovided for emergent situation, threat to the hospital system has passed. Every problem they identify as being addressed by the governor's proclamations has a statute to cover it. And the emergency authorization statute can't allow the governor to simply say, I don't like what we have on the books. I won't call the legislature into special session. I'll just maintain an emergency for as long as I want. If he doesn't like the existing statutes, as Your Honor pointed out, there's a mechanism to call the legislature into special session. I wanted to say one other thing about the legislature's ongoing approval of certain suspensions. There is no mechanism at all in 4306-220 for the legislature to address the governor's continued suspension of civil liberties. And that's a very important distinction between the things the legislature has the authority to approve and has periodically approved by letter, and the things for which there's no legislative recourse, and for which the recourse for these plaintiffs is only to the courts.
Okay, but didn't the legislature provide this authority to the governor, so therefore could take any authority away in this respect?
Well, Your Honor, the authority they provided to the governor is limited. It's not limited by time in 210. So I would say there's sort of two buckets of authority. Declare a proclamation, and there's a limit on how long.
Uh-oh. Something happened. we may have lost the courtroom feed. I'm going to try to connect with our court staff to see what's going on. Okay, we're going to take a 15-minute recess. We'll resume back at, let's just say we'll resume at 12:20. And hopefully by then we'll have been able to sort out what's going on with the connection to the courtroom. So Mr. Jones, I realize we still need to get to your motion and I intend to do that. But we'll take a little over 15-minute break and we'll resume with that, okay?
Thank you, Your Honor.
All right, thank you. All right, is everybody ready to begin? To resume?
Yes, Your Honor.
All right, Mr. Ard, go ahead. Oh, you're on mute.
How's that, Your Honor?
Yes, I can hear you.
Thank you. I apologize to your deputies for running out the battery on their equipment here. What I was saying was the legislature has given the governor, I would say, authority in two buckets with sort of two sets of limitations. The one I'm focusing on is not the one that Mr. Even is focusing on. I'm focusing on the authority to have an emergency at all. It is fact limited under 4306-210. The emergency proclamation must be voided when, as a matter of fact, order has been restored. If the governor does not elect to revoke his proclamations when order has been restored, that must be subject to judicial review. That's the kind of question that is presented to courts routinely. Does this conduct comply with existing law? Examine the facts, examine the law, and resolve that question. It's not something for which there's a need for judicial deference, nor is it something that the courts should abstain deciding pending the legislature by double supermajorities calling itself back into session. It's completely within the court's competence to review. During an emergency is what Mr. Even's focusing on. Let's assume there's an emergency. Isn't it scientifically sound what the governor's doing and Mr. Ard has no experts? We're not challenging that the governor in good faith thinks he's making scientifically sound decisions. What we're saying is he's making decisions that the legislature says are not his to make. And he can't simply say, I prefer that I make these decisions and it's a good faith preference and therefore there's no judicial review. So in this question of within the 220 authority, even there it's subdivided. Some things that he can declare remain in place more or less perpetually, but only as long as there's an actual emergency. Other things the legislature has to allow him to renew. But again, what we're looking at, and I think Your Honor saw this very clearly, is the fact limitation of whether or not there is an emergency at all. A couple other minor points. Mr. Even suggested that we're asking the court to micromanage this. Again, that results from a focus on what the governor's doing under 220, not a focus on 210 and whether there's an emergency. Again, if the problems that we're facing are covered by an existing statute, it's not for the court to micromanage it. That existing statute gives the responsibility for addressing those problems to county and local health authorities in coordination with the State Department of Health. So again, it's not as though we're asking the court to step out of its core competency and micromanage a response to a health problem. And then finally, and very briefly, we will augment the record this afternoon as Your Honor requested. I think a number of the things that Mr. Even pointed to are judicially noticeable. We'll make sure that that data is clear on where it came from. Dashboard does provide county by county data. It's a little quirky to interact with, but I'll try to provide that and make it clear where that came from. The various public official statements on their official letterhead will be augmented with declarations. And Your Honor's concern about the testing ratios, again, it's our view that what Your Honor's pointing to is a very good reason why the legislature decided to impose local control as an initial matter on these kinds of problems. There's obviously different circumstances in Chelan County than in many places. And I think the specific issue you were pointing to is the fact that Stemilt, just one of the outstanding employers in the area, has implemented an extraordinarily proactive and aggressive testing program and will present you with a declaration, I hope, for perhaps their HR director or someone describing the contours of that program. I think what you'll see is that among Stemilt employees, the per capita testing rate exceeds practically anything anywhere in the state. The company is being so careful about their workers. So again, we're not asking you to decide whether that's a good idea or a bad idea. What we're saying is the legislature has already made that decision. They have already determined that Chelan Douglas County Health Authority, working with employers like Stemilt, are the first line of defense and response to a virus like this. It's not an emergency simply because it exists. It's only an emergency if the problem exceeds the bounds of existing statutory and regulatory regimes. If Your Honor has no further questions, I will rest.
Okay. No, I don't.
Your Honor, may I briefly add one point in response to Mr. Ard?
You may, but since he's the moving party, I will give him the opportunity to respond to you.
And I realize at this point, saying anything, hearing anything from me is simply by grace. That's correct. But I would point out that the issue we're talking about here about when an emergency ends is addressed in the Cougar business owners case regarding Mount St. Helens, which is in the materials. And the argument there was that the governor had been premature, but the emergency continues even after the actual event has taken place. So what Mr. Ard is arguing today would be similar to if the plaintiffs in Cougar business had said, yeah, we understand that you can have an emergency when a volcano erupts, but as soon as the lava stops flowing, it's over. Well, that may or may not be true, depending on what the effects of the lava flow are and on the explosion that occurred. And so in this case, the governor can reasonably determine that emergency continues to exist so long as we are at a risk of a rebound, such that the original reasons for the declaration of emergency could easily recur. So I think just as a matter of law, that is a point that cuts strongly in the governor's favor. And unless that provokes a question, that's all I'd say about it.
Your Honor, I would briefly address that. Obviously we agree. Am I muted? No. Okay. Obviously we agree. The Cougar Business Association case, I think, is a great example for us. It shows why we're right. I appreciate Mr. Even bringing that up. The governor obviously can proclaim an emergency when USGS or other experts predict that a volcano is about to erupt. You don't need to wait for it to erupt. That's what we saw here. After the eruption, if there's no statutory scheme sufficient to address the problems that result from such a catastrophic event, the emergency can be maintained. But when conditions have subsided to the point where existing statutory and regulatory schemes designed by the legislature explicitly say that they are set up to cover the circumstances that remain, the governor can't continue the declaration of emergency. Mr. Even says that he suggests the governor can maintain that declaration of emergency if there's some risk predicted by some expert that if the emergency proclamation orders are not maintained, the old emergency will recur. And of course, I think that gives the game away. That's why we're entitled to a TRO. He's suggesting that if the governor can show that lifting the proclamations and handing control over response to this virus to the Chelan County Local Health Authority or every county local health authority, and the responses that they will take, which do include measures to respond to the virus. The governor wants to say if he could show that doing that would result in a threat to overwhelming the hospital system, there's still an emergency or an anticipated emergency that justifies the proclamation. That might be true, Your Honor, but the governor absolutely can't show that. He makes no attempt to show that. There is no model in evidence before you. There's no model that I'm aware exists anywhere where IHME at University of Washington or anyone else says, I have looked at the Chelan County and the Clark County and the King County and the Pierce County and the Spokane County health system response plan for a flu, and those are so inadequate to the task at hand that if we let them do what they have trained and prepared to do, the state hospital system will collapse. That's what Mr. Even says justifies maintaining the state of emergency, and he can't show any evidence from anyone anywhere that that is predicted to happen. If you hand the reins back to the local authorities in coordination with the Department of Health, according to existing statutes, there is no threat to overwhelming the state hospital system under any circumstance that you will find in this record or in any other evidence that he could muster and submit. And for that reason, that's the very reason that under 4306-210, order has been restored in the area affected. The governor must terminate the state of emergency proclamations.
All right, thank you. We can move on to the next motion. I'm not going to make a decision, like I said, right away, because I am going to provide the plaintiffs with the opportunity to supplement the record with the declarations so that I can actually consider some of the documents that were submitted attached to Mr. Ard's declaration. And I just want to state, moving into this hearing and also the last hearing, I understand that this is a very, these issues impact people deeply in their health and in their livelihoods and their homes and their community. And I don't want to, in any of the rulings, I hope that everybody realizes that the court has to make decisions based on the law and the law that's been presented to the court from the parties. So I'm intending to do that both for everything that is presented in front of me, and I want to make sure that that's really clear. This is not, I think that there's some concern just from some of the things that I've read in the pleadings that there's some political issues here, and the court does not interject in political issues. The court is going to decide the case on the law. So with that, we'll move into the motion for transfer of venue, which is a procedural legal issue that we need to address, because that's something that, moving the case forward, we need to know where this case is going to be heard. Mr. Jones, this is you're going to be arguing this motion, correct? Oh, you're muted.
Thank you, Your Honor.
Go ahead.
Our motion for change of venue is based on two venue provisions. The first is a mandatory provision under RCW 4.12.0202. That's for mandatory change of venue for cases involving public officers for acts done in virtue of their office, where venue is mandatory in the county where the cause arose. If the court denies that motion, then in the alternative, we also ask for a discretionary change of venue under 4.12030, which allows for a discretionary change of venue in the interest of justice or for the convenience of witnesses. So my primary argument will be addressed towards the mandatory venue provisions of 4.12.020, then I'll address the discretionary venue change. So as I mentioned, there are three considerations here to determine where venue should be under the mandatory venue statute. First, is it against a public officer? Second, is it for an act done in virtue of his or her office? And third, is it in the county where the cause of action arose? As I understand plaintiff's position, they do not contest that the governor is a public officer for the purposes of the venue statute. And I should state now for the record, Your Honor, that we have not been served with any opposition brief in this matter regarding our motion for change of venue. So I'm not sure if plaintiffs have filed an opposition in this matter, but I will address the arguments that they raised in what is likely to be a substantially similar opposition brief that they filed in the pending Douglas County matter of Sutton versus Inslee.
Well, we do need to address that because they did file an opposition. And so if you weren't served with that, that's a problem.
Your Honor, I apologize for that. The oppositions, as Mr. Jones recognizes, are in all respects identical, save the caption. And I apologize for an oversight in failing to serve both documents. I will make sure that happens promptly, but they are in fact identical in all respects in terms of the substance of the argument.
Okay, Mr. Jones, do you still want to argue it today, or do you want to? Okay.
Your Honor, we're willing to proceed, operating under the assumption that Mr. Ard's representation is correct, that they are substantively identical, and I have no reason to doubt him. Hopefully they get a find all and replace Douglas County with Chelan County, at least, for all that. And this is actually as good a time as any to note, Your Honor, because against the backdrop of this is not just a venue motion to be considered in isolation. The court should also have the benefit of understanding that this is one of many actions brought around the case, most of which were brought by, around the state rather, most of which were brought by plaintiff's counsel. Simper versus State is pending in Lewis County. Atchison versus Illinois is pending in Whitman County. Sutton versus Illinois is pending in Douglas County. And then of course, this is Cuevas and Chelan County. The last three, so Atchison, Sutton, and Cuevas present virtually identical theories and claims. Simper raises a separate claim under the paramount duty clause relating to public schools, but Atchison, Sutton, and Cuevas are copycat cases. There's a fourth case rather, separate from this one, McEwen versus Inslee, that plaintiff's counsel have also filed, this one in the Western District of Washington. It's one of several cases challenging the governor's stay home proclamation in federal court, all of which have been assigned to the same judge in the Western District of Washington for largely the same principles that we would argue these cases should appear at least in the same county, if not consolidated before the same judge. Your Honor, I'm just checking to make sure that you can hear me okay as well, because my screen is going a little haywire.
I can hear you.
Okay. So just against that backdrop of all these different cases pending, three of which raise identical claims, we have this change of venue motion, which in our view, the text is very clear of this mandatory venue statute. It is against a public officer. It's in virtue of his office, the proclamation is, and the cause of action arose entirely, in whole and in part, in Thurston County, where the governor issued the stay home proclamations. I understand plaintiff's opposition in the other case, at least, challenges the idea that the proclamation was issued in virtue of the governor's office. Their argument is apparently that because their contention is that the proclamation is unlawful, that it exceeded the governor's emergency powers, that the proclamation is not issued in virtue of his office. That is clearly incorrect under all cases of which I'm aware in this state. That's articulated nicely in the Supreme Court's relatively recent decision of Eubanks. In Eubanks versus Brown, the Supreme Court held that an act done by a public officer in virtue of his office is an act exercising or failing to exercise the authority of the office or performing the authority in an improper manner. So the question is not whether the act is authorized. The question is whether the act is issued with the authority of the official's office. In that case, clearly the proclamation pursuant to the governor's emergency powers is issued with the authority of his office. And the Supreme Court relied on several other cases in Eubanks, State ex rel McWhorter versus Superior Court, in which an agent of the State Humane Bureau was sued for improperly charging the plaintiff with animal cruelty. And even though the allegation was that this was an abuse of the official's power, the court held that the cause of action had to proceed under the mandatory venue statute where it arose, which is to say where the officer took the act that was being complained of. I believe it was in King County in that case. Similarly, in Euchre versus Douglas County, a more recent case, the Eubanks court relied on Euchre, which was a lawsuit against police officers for alleged false arrest, false imprisonment, and malicious prosecution. Even though the nature of the allegations in that case were that the police officers exceeded their authority and acted unlawfully, the court held that the same venue statute, the mandatory venue statute, applied, and the case had to proceed in the county where the cause arose, which is to say where the officer's allegedly unlawful acts occurred. It's very clear that this cause of action is a case against the governor for exercise in virtue of his authority, in virtue of his office. So moving on to the third prong of whether the cause arose in whole or in part in Thurston County. Like any other case with statutory construction, the court has to begin with the plain and ordinary meaning of the text of the statute. And the word arise in common parlance and in dictionaries, including legal dictionaries and very widely used Webster's dictionary, arise means originated or resulted from. And this cause of action, this lawsuit, resulted from the governor's proclamations, which, again, and there's no dispute on this point, were issued in all of the proclamations were issued in Olympia in Thurston County.
Okay, so I have one question for you on this. This is, and I think plaintiffs have made this argument that, and just generally, we know that a cause of action requires an act, damages, and then the cause, that the act caused the damages. So I understand what you're saying, that the act occurred in Thurston County, but what the plaintiffs are saying is that the damages, which is a requirement for a cause of action, have occurred in Chelan County. So if you could speak to that.
Yes, Your Honor. So I agree that although I don't think plaintiffs have quite clearly articulated what they think arise means, I think their definition would have to include some kind of interpretation where arise means damages were felt or suffered by the place where damages were felt or suffered by the plaintiff. And it's just not possible for the legislature to have used arise to mean the place where damages were suffered. And you only have to look to the very previous section of the venue code here, to 4.12.010, because in that statute, the legislature provides for venue. It says actions for the following causes shall be commenced in the county in which the subject of the action or some part thereof is situated. 1, for any injuries to real property. So the legislature knows how to create venue where the injury occurs. In this case, for a local action, an in rem action to real property, by saying actions will be in the county where the subject of the action occurs or where the injuries occur. The different language that the legislature used here, using the word where the cause of action arose, that is meaningful variation that the court has to credit, and it completely undermines plaintiffs' damage-based theory of venue, as does simply the plain meaning of the word arose, which doesn't suggest anything to do with what the effects on the actual plaintiff are. So plaintiffs don't identify any cases to fit their damages-based theory of venue. The only cases they cite are personal jurisdiction cases, 2 of them, I believe, that don't really have anything to do with this specific standard of where for venue purposes, a cause of action arose. In Prusinski versus Ashby, a Court of Appeals case that was, they cite the Court of Appeals version, it was affirmed by the state Supreme Court. In that case, you had an Idaho trooper who pulled over the plaintiff in Washington. He observed her driving erratically in Idaho and then followed her with his lights on across the Idaho-Washington border. And in Washington, the trooper pulled her over, and the Court of Appeals in the Washington Supreme Court affirmed that personal jurisdiction was proper. It was under the long-arm statute and due process standards because, quote, all of the acts giving rise to Ms. Prusinski's claim occurred in Washington. Now, to the extent this case is at all analogous to the venue statute, it supports the governor's argument because all of the acts giving rise to plaintiff's claims here occurred in Thurston County. It's only the alleged effects that may have occurred in Douglas County, and that is not where the cause of action originated or resulted from or arose. Those all occurred in where the proclamation was issued. And another point I'd raise, Your Honor, just going back to the damages analogy, is that in this case, they're not even really looking at plaintiff's damages. There is no claim for damages as I read the complaint. What they're asking for is injunctive relief and declaratory relief in validating the governor's proclamations. So to the extent damages, they're alleging that damages have occurred in Douglas County, or excuse me, in Chelan County. Now I'm getting the county names mixed up. In Chelan County, it's completely irrelevant to the resolution of the legal claims that they bring in this case, as well as to the relief that they're seeking to be ordered. The second personal jurisdiction case they cite, Your Honor, is even less on point. That is Grange Insurance Association versus state. Plaintiffs cited this, again, for the proposition that you have to look to where the damages occurred. But again, in that case, the Supreme Court held that personal jurisdiction was not proper because Idaho did not purposely avail itself of Washington jurisdiction when it sent cows that were tainted across the state border. So the court had no reason in that case, because it determined that there was no purposeful availment and thus no minimum contacts. It had no reason to reach the second factor under the personal jurisdiction due process standard of whether the cause of action arose from or was connected with Idaho's act in Washington. I'll also point out just the very plain text of the of that second factor in the personal jurisdiction standard is different than this case. It says arose from or connected with the defendant's act. So that's a much broader standard, even if plaintiffs had cited a case that suggested personal jurisdiction was proper. It's an entirely different standard just by the plain text. So plaintiffs assert that there's extensive case law defining what it means for a cause of action to arise in a particular county, but that's an astonishing statement because they don't cite a single case involving venue under the venue statute. The only case they even mention is the case that the governor cited, which is Chambers versus McGee Guest House, Inc., 64 Washington App 1011. It's an unreported case, so of course it's not precedential, but we think it's pretty helpful in this case as one of the few cases interpreting what it means for a cause of action to arise. So in Chambers, the decedent was admitted to a boarding house in Pierce County, and eventually wandered away from the boarding house and died. And the plaintiff, who is the executor of his estate, sued the boarding house in a different county, in Grays Harbor County. And the courts held that under the mandatory jurisdiction statute, venue was proper only in Thurston County because the cause of action arose in Thurston County because that was where all of the defendant's acts had taken place. Plaintiff argued, well, in deciding to admit the decedent to the boarding house, you called Grays Harbor County, you called the decedent, you faxed documents to Grays Harbor County, and the court said that no, that doesn't count. All of the acts committed by the defendant, the boarding house, were committed in Thurston County. And we think that points strongly in favor of our position that because all of the acts of the defendant, the governor, occurred in Thurston County, that's where venue is exclusively proper. And that interpretation is consistent with the weight of authority from other states. Again, plaintiffs criticize the governor for relying on authority from other states, but this is a very common practice in statutory interpretation, looking to other jurisdictions with similar statutes for help and assistance and guidance as to how our similar or borrowed statute should also be interpreted. And I don't hear plaintiffs challenging that the majority rule across the 10 to 12 jurisdictions that we cite is that under similar statutes where for lawsuits against public officers in virtue of their acts are brought, arose means in the county where the officer acts. Probably the best case, or probably the most clear case for our purposes, is the South Carolina case that we cite. It's Stallheim versus Doxasil, 269 Southeastern 2nd 346. And that's kind of like a play on the Chambers case, actually, with a little bit of twist in the facts. So in Stallheim, the patient in a state mental hospital, escaped in one county and allegedly killed the plaintiff's husband in another county. So here we have two different actions. We have the defendant's action, the negligence of allowing the patient to escape in one county, County A, I'll call it. And then in County B, we have the damages that occurred. That was the death of the plaintiff's spouse. And the court held that under a very similar venue statute, the venue statute said, actions against a public officer for an act done by virtue of his office must be tried in the county where the cause or some part thereof arose. And the South Carolina court said this entire cause of action arose where the defendant's allegedly wrongful acts took place. And it wasn't just based on the plain text of the statute. The court also very sensibly looked to the policy consequences of interpreting it otherwise. The court said, if it were otherwise, public servants might be required to defend lawsuits in any distant county of the state and encounter inflamed local feelings and prejudice. At this point, the plaintiff's private convenience must yield to the public good. That's exactly the situation we have clearly emerging right here, where already there are 3 lawsuits brought by the same plaintiff's counsel in 3 different counties, presenting an obvious risk of inconsistent opinions, inconsistent results, and conflicting obligations to be imposed on the governor, on county officials, and on individual citizens alike. And I think that this case, along with Sutton, presents probably the starkest example of that risk of inconsistent results and the damage that would occur as a result of it, where the counties share a public health district. So if this court rules one way and the Sutton court rules another way, it's going to put pressure on the shared health district, the Douglas Chelan Health District, whose judgment is it supposed to follow, as opposed to consolidating all these cases as the venue statute clearly mandates in Thurston County where the cause of action arose.
All right, and that is a good point. But Mike, I have a question about the inconsistent results, and taking the Douglas County case aside, because yes, we do share health district, and that and obviously we have a lot of similarities, but I do have concerns about this idea that other counties that may not be anything like our county in terms of the current COVID threat, should be treated exactly the same.
That's certainly not what we're arguing, Your Honor. To the extent plaintiffs' claims hinge on county-specific allegations, and I have to say, I don't think their legal claims do at all. I think the legal claims are entirely matters of statutory interpretation, constitutional interpretation, perhaps, and don't hinge on local conditions. But to the extent, if the cases were to proceed and local conditions came into play, it would be entirely appropriate for the court in Thurston County to examine those local conditions. I don't think there's any sense that simply by transferring venue that the local conditions in different counties would be disregarded. That would be inappropriate if they were relevant to the adjudication of plaintiffs' claims. And I think it's an important principle that you see in a lot of these change of venue cases, that the court has to assume that all counties across the state are equally competent of adjudicating particular types of claims. So there was one case, I forget exactly the name of it, where the court transferred venue because of a specialized knowledge or expertise of the transferee court might have had. And the Supreme Court reversed, saying, no, we have to assume that all counties, all superior courts across the county are going to just discharge their duties, and even if it involves complex factual or expert determinations. I'll take a look at that case and try to get it to you, Your Honor, if you'd like to see it. And I think that's an important principle here, that we can trust the Thurston County Court to fairly adjudicate even localized factual determinations to the extent they need to be made. So the one case that plaintiff cites on venue that actually supports their position is out of California. And the governor freely concedes that California is one of the very few states applying the minority rule here for these types of venue statutes, where venue is proper in California wherever there's a plaintiff who says he suffered damages as a result of the governor's action or of the state official's action. In California, which is again the only case that plaintiffs cite, the legislative history in this newer statute, the court looked to that legislative history, which specifically indicated a legislative purpose to change the rule to allow it to be more plaintiff friendly, to ease the burden on plaintiffs from different parts of the state for suing state officials. So there's no legislative history remotely indicating that that was the legislative purpose here in 1941 when this venue statute was enacted in materially identical form. So as the court considers legislative intent, in the absence of any legislative history suggesting that plaintiffs' damage-based theory of venue should control, the court should consider the pernicious consequences of a rule that would permit venue wherever an official's act has an impact. And to be clear, it's not limited to just the residence of a plaintiff. Under plaintiff's theory, if venue is proper wherever an official's action is felt, wherever there are damages, any statewide action could be brought by any plaintiff in any county. So the plaintiff's actual residence is irrelevant, meaning a plaintiff in King County could bring a lawsuit in Okanogan County simply because he makes allegations that a statewide action has effects in Okanogan County. That would present chaos. It would be extremely detrimental to our orderly system of venue and judicial administration. And this is not, again, a slippery slope type of argument. We see this very same thing happening here, where plaintiffs' counsel, plaintiffs' firm have filed essentially look-alike lawsuits in 3 different counties, a 4th lawsuit that's different, but also challenges the governor's proclamation in a 4th county, and then a lawsuit in federal court as well. I mean, this is not just forum shopping, Your Honor. This is a forum shopping spree. And we have a venue statute that clearly channels this case into Thurston County where the cause of action arose, because that's where the governor's decision-making act was made.
Okay, but we're not talking about a situation where the current proclamations are treating all of the counties the same. Some of the counties are under different phases and have different, at this point, they are being treated differently. And so it would be a different situation where there was a proclamation that addressed or that affected all citizens in the same way, because it's directed at all citizens in the same way, as opposed to this is not directed at all citizens in the same way.
Well, I think what I hear Your Honor saying is that if there were a proclamation or any kind of executive action that was specifically directed at one county or fewer than all counties, I think that would be a very different case. Now, under the strict kind of textualist interpretation of arose, if the action took place solely in Thurston County, I still think that that our interpretation of the venue statute would apply. But I think it would be a very different case. And I don't think the court needs to rule that way in order to find venue exclusive and proper in Thurston County. So, for example, you know, the plaintiffs mentioned the Cougar business owners case. Although the case has absolutely nothing to do with venue, plaintiffs suggest that somehow the court decided that venue was proper in Cowlitz County. Now, that is a very different case, obviously. It wasn't like Cowlitz County was just randomly selected as a venue because some plaintiff alleged a harm there. The Cowlitz County had a very important locus in connection to the Cougar business owners case. That's where Mount St. Helens is located. So for venue to be proper in that county where the state of emergency was specifically directed towards that county and the county surrounding Mount St. Helens made a lot more sense than it would in a statewide situation. Because, you know, so even if the court imposes a limiting principle saying, well, for a statewide action, venue is only appropriate in Thurston County. And I think that would be a perfectly satisfying limiting principle in this kind of a case. The court need not reach further. But plaintiff's theory offers no limiting principle whatsoever. If it's truly the case that as long as you allege damages in one county, you can bring a challenge and that venue is proper in any county, and venue is proper in that county where damages are sustained, there's no limiting principle. There's no end to where the statewide official is going to be sued. And so it creates this red meat opportunity for multiple lawsuits across many different jurisdictions in the hope that you know, they'll hit the jackpot on one of them. If the court doesn't have any further questions about our mandatory transfer of venue argument, I'd be happy to briefly address our argument in the alternative for transfer of venue for the convenience of witnesses and in the interest of justice.
Okay, go ahead.
So again, in the opposition that plaintiffs filed in the Sutton case, they make the statement that we haven't asked for such relief under the statute, but we think our motion's pretty clear that in the alternative, we would seek a discretionary transfer of venue under 412-0303. So the text of that statute, again, is pretty clear. The court may, on motion, meaning it's permissive, change the place of trial when it appears or by affidavit or other satisfactory proof. 3, that the convenience of witnesses or the ends of justice would be forwarded by the change. So again, because plaintiff's complaint does not raise any Douglas County Chelan County specific allegations, there's no reason to think that there's going to be material witnesses in Chelan County. Assessing the legitimacy, the validity, the public health backing, and the scientific and epidemiological data behind the governor's decision, that's all state officials who are with the governor's office, with the State Department of Health. Those witnesses are all in Thurston County. Second, and I think maybe even most importantly, the ends of justice would best be served by transferring this case and all other cases raising similar claims that are not local specific to Thurston County. We cite several cases from federal courts saying that the potential for consolidation is strongly weighs in favor of the interests of justice and strongly weighs in favor of a discretionary transfer of venue. We also cite the Clampett case, 98 Washington 2nd 638, that says considerations of judicial economy and preserving judicial resources and avoiding conflicting judgments are all legitimate considerations in the interest of justice under the venue statute. So the concern here, the alternative, allowing all of plaintiffs' lawsuits to go forward in all these different counties creates certainly a risk of inconsistent judgments and competing obligations for the very same county officials as the Douglas Chelan Joint Health District problem points out, makes very evident.
Okay, I want to go back to the convenience issue.
Yes, Your Honor.
It's a very rare situation where we actually are conducting court hearings via teleconference and video conference. So why is that different? Why is it more convenient to have it in Thurston County versus Chelan County if this is how we're going to be conducting the hearings anyway?
Yeah, that's a really good point, Your Honor. I guess it would be a wash in that case. But this is, of course, assuming that the status quo is preserved, meaning that we remain in a work from home, litigate from home kind of scenario. Plaintiffs, of course, would have it the other way, where county by county, the governor's proclamation would be overturned. People would be going to court in person. So I'm not sure which way that cuts, but it's just worth considering that our position is the proclamation should remain in place. If that's the case, no TROs are granted, no emergency relief is granted, then I agree. The convenience of witnesses, as long as we're still conducting matters by Zoom, would probably be a wash in that case. But the interests of justice arguments obviously still remain the same due to the risk of inconsistent results and competing obligations on state and local officials.
Okay, and in that you're more focusing on the legal issues having differing results.
I'm not sure I understand the question. You might have cut out just a little bit.
Well, I had raised the concern about having there be factual differences between the different counties, but you had said having inconsistent legal rulings on the legal issues is it appears to be more of a concern.
That's how I read the complaint and their allegations, that really it's a question of statutory interpretation that Mr. Ard and Mr. Even disputed, but there weren't really local conditions. So just for example, Your Honor, we have a system of county by county variances that are in place. More than half of the state's counties have been granted variances to move into stage 2. So if you had a claim where a county applied for a variance and that application was denied by the state, that would be a very different fact pattern as this one, where the county is essentially saying, hey, you're treating me differently. You're treating me unfairly. I've made this application. And it's not just different legally, it's potentially different in terms of venue, because in that case, the county is making, the state is making local specific determinations. So I think you would have a much more plausible argument for the cause arising in that local county that was denied specific relief. But that's not what plaintiff's argument is. Plaintiff's argument is you can't apply the state, the proclamation anywhere because it's unlawful. Plaintiff's argument is that the influenza statute is the one that should apply everywhere because that preempts or precludes or trumps the more general emergency powers statute. So there aren't local issues that need to be determined in order for the court to resolve the legal claims raised by plaintiffs in their complaint.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Ard.
Thank you, Your Honor. I would say first that the text of the statute is obviously the place to start. It's also the place to end. And I'll focus really on 020 4.12.020 because that's where the governor's lawyers really do put all their chips. The important thing, I think, is to look at the entire statute. We refer to this a little bit in our opposition. I'm going to be more thorough, I think, than the papers were in our sort of fast attempts to respond to quite a lot of pleadings from the governor that came in, maybe not as thorough briefing as I would have hoped for. Counsel for the governor continually refers to first damages, which are not an element. It's harm, not damages. And we have alleged harm for which we seek injunctive relief. No party to this case has sought money damages. And he repeatedly refers to the statute as placing a venue where the cause arose, but that's not exactly what the statute says. There's 3 subsections here. It's important to look at all of them. Actions for the following causes shall be tried in the county where the cause or some part thereof arose. This is an explicit acknowledgement by the legislature that the kinds of causes identified below are ones that can have portions arising in different places. You wouldn't use that language if the cause could arise only in one place. So we have the recovery of a penalty or forfeiture imposed by statute against a public officer. And then let's look at the third one, because one important canon of statutory construction, Your Honor, is that when we use that same phrase in 2 different places in the same statute, it means the same thing. The third one is for the recovery of damages for injuries to the person or for injury to personal property. The plaintiff shall have the option of suing either in the county where the cause of action or some part thereof arose, or in a county where the defendant resides. And we know what that means. Tort claims arise in multiple counties. They arise where the challenge act was taken, and they arise where harm from the challenge act was felt. And I'd say a couple things about how that relates to Chelan County. First of all, obviously all the harm alleged is felt here in Chelan County. Next, the governor, in his official capacity as governor of the state of Washington, is absolutely acting in Chelan County. People in Chelan County are barred from leaving their homes for various reasons. They're barred from gathering together. They're barred from worshiping by threat of enforcement, and in fact, by actual enforcement by the governor in his official capacity as the governor of the state of Washington here in Chelan County. Chelan County businesses that attempt to act contrary to the proclamations have officers from the executive branch come to them and force them to stop acting in ways they wish to act under these proclamations. So the actions are taking place in the county.
Okay.
If the governor, yes, Your Honor.
Where in your materials has that happened? I mean, that's a question that I have here because we're talking about proclamations that we're not, my understanding was looking at the materials that we weren't talking about issues where somebody has had state action on them because in terms of enforcement. And so they're complaining about that action, but that the complaint is about the proclamation itself.
Yes, Your Honor, and that's an issue that all we need for standing is the threat of enforcement. And to say that the cause of action, that none of the governor's actions are in Chelan County, would be to require one to conclude that there's no threat of enforcement in Chelan County. But plaintiffs who intend to abide by existing law and yet challenge it have standing to do so because of the threat of enforcement. The proclamation may be written in Thurston County, but it explicitly threatens enforcement in Chelan County, and the harm is felt in Chelan County. And that's identical to what happens with the identical language in 4.12.020 sub 3. That's the kind of issue that superior courts around the state face as a routine matter, that damages for injuries to the person can be filed where some part of the cause of action arose. And that's an explicit recognition by the legislature, just as it is in the preamble of the statute that governs Section 2, that the action can arise in multiple places. And so to whatever extent the action arises in part because the governor acts in Thurston County, it arises in equal part in Chelan where the harm from those acts are felt. It's common to all manner of tort law. I would also say that there are things that are not said in subsection 2, which are said in subsection 3 and compel the conclusion that the cause of action arises in both places. Obviously, there's a locus for an official. And if the legislature wanted all acts against state officials to be filed and to proceed only in the county where that official was located, they could quite clearly have said that, and they didn't. For example, in Section 3, it says that for the recovery of damages to the person, it can arise where the defendant resides at the commencement of the action. One could quite easily have used that identical language in 4.12.020 sub 2 if you wanted acts against officials only to be filed where the official resides. Just say so. They didn't say that. They said that harms flowing from official actions can arise in more than one county, and we know that because they say where the cause or some part thereof arose, clearly showing that it can arise in multiple places and the plaintiff can elect. And they didn't specifically say that it only arises where the official resides or that the claim can only be brought where the official resides. The language they would have needed to do that kind of thing is quite plain. It's right there in the statute. The fact that they didn't elect to use that shows that the acts by an official can create harm and can create a cause of action in more than one county. And I'd say very commonly they would not, right? Claims against county police are typically going to arise in the county where the police officer acts and where the harm is felt, where a person is when the harm happens. But in the case of a statewide elected official who seeks that office where his or her actions can in fact affect people all over the state, the legislature has made the decision that is quite plain in this venue statute that by seeking that office and taking statewide office and acting in a statewide manner, the official opens himself up to being sued in any county in the state. This is hardly any imposition on the governor. We're suing him in his official capacity. He's not going to appear. He's not going to come to Chelan County and show up in court. It's an official capacity action, which will be ably handled by the 600 attorneys at the Attorney General's office. It's no imposition whatsoever on a statewide official sued in his or her official capacity that the cause is heard in the local community where the harm is felt by the local courts.
Okay, but what about this issue that there's multiple cases that have to be defended and could result in different legal rulings?
So that has, first, Your Honor, nothing at all to do with the mandatory venue statute 4.12.020. And counsel for the Attorney General is, I think, quite out of bounds in asserting that my clients in Chelan County are not entitled to the venue they selected merely because clients in other counties have hired me as well. He certainly couldn't make those ridiculous arguments if they'd hired other counsel. And the fact that I'm lead counsel on this variety of cases has absolutely no effect on the venue statutes or the proper interpretation of venue. The question of venue is not who the lawyer is. The question of venue is who the client is. Sure, there can be the possibility of inconsistent results, and perhaps the circumstances on the ground in Whitman County, as the governor, in our view, impermissibly under these proclamations treats Whitman differently, might come to a different result. It is the case that we think it's a purely legal question that any court can examine without regard for local conditions, and I think that's, Mr. Jones ably made my merits argument on the TRO for me in that sense. But inconsistent results in different courts is not at all unusual. It happens all the time. It's why we have an intermediate appellate court system and a Supreme Court. In fact, it's almost undoubtedly true that the Supreme Court could take initial appellate jurisdiction of any decision in these cases. It's not unusual. It's not abnormal. It's required by the venue statute that where a state officer makes statewide actions that affect people in different parts of the state, if people in different parts of the state elect to challenge that in their local courts, decisions will be made, decisions will be appealed. There will be uniformity of law in short order when the Supreme Court gets those cases in its hands and looks to them. That doesn't affect the venue that's proper in this court as an initial matter. And again, the key language there is that the venue statute recognizes the possibility of a cause arising in multiple counties by specifically identifying some part thereof. Looking to the variety of out-of-state law, Your Honor, I'm not sure that there is really such a clear majority rule. Language like this is in fact used in a lot of states. State Supreme Courts have treated it differently under various very fact-specific issues. Even the South Carolina Supreme Court has gone back and forth on whether their venue statute requires claims against officials, statewide officials, to be tried in the state capitol. They've gone both ways on that. Other courts that have looked at this, Montana, for example, has allowed claims against state officials to be tried in the county where the plaintiff resides and feels the harm. I think the language of our venue statute in 020 sub 2, exactly like the language in 020 sub 3, should be treated exactly like the state treats venue in 020 sub 3, and that's that a cause of action arises both where an act is undertaken and where harm from the act is felt. On the request for permissive transfer, Your Honor, again, it seems as though the state has effectively conceded that there aren't likely to be any witnesses in this case. If there are going to be witnesses, I think Chelan County plaintiffs are as likely to be witnesses as the governor's epidemiology experts, and I hardly think it's in the interest of the convenience of people who want to either appear as witnesses in their own claim or even simply attend court, as is their right in a case that's being heard, to be forced to travel to Thurston County for the convenience of a group of government employees who, as Your Honor points out, can readily appear by Zoom or other technological measures. So in terms of the interest of justice, the idea that different superior courts might give different decisions, that's why we have intermediate appellate courts and a unified Supreme Court. It's not unjust for cases to move through from lower courts to intermediate courts to Supreme Courts. It's how the law works. And in terms of the interests of witnesses and parties to the action, people in Chelan County have obviously a great interest in being able to attend court, go to court. To the extent that they're called on to be witnesses, it's far easier for them to be witnesses here in Wenatchee and Chelan County than to be witnesses anywhere else. I think the permissive transfer is certainly a burden for the government to show that they're entitled to that permissive transfer, because the plaintiff is normally entitled to his selection of venue. They certainly can't meet that burden for all the reasons Your Honor has shown. And in terms of mandatory venue, because the statute explicitly recognizes that a cause of action can arise in 2 counties, sure, it may have arisen in part in Thurston, and we could have elected to file in Thurston, but these plaintiffs are Douglas County plaintiffs, and they want their Douglas County harms adjudicated in the Douglas County Court. They're entitled to that.
I think you meant Chelan County, but I.
Thank you, Your Honor. I absolutely meant Chelan County.
Right.
I apologize.
Okay.
Now we've each done it once.
Anything further, Mr. Ard?
No, thank you, Your Honor.
All right, thank you. Mr. Jones?
Thank you, Your Honor. So plaintiff's new argument, and it is a new argument, at least it wasn't in the Douglas County opposition brief. Again, I haven't read the brief they've submitted in this case, but in the Douglas County opposition brief, there's no argument that you should look at 412.020 paragraph 3. As I understand plaintiff's argument today, that they're making in person today, it's that the injuries to the person language suggests that the different paragraph should be applied in the same way. But I think the fact that it's in the third paragraph, that third paragraph is mentioning injuries to the person, that's meaningful variation, that it's not in the second paragraph. The second point on that is nothing in the paragraph 3 mentions what happens if there are injuries in different counties. So I couldn't quite wrap my head around what hypothetical plaintiff was getting at. But I guess if his argument is the government or the state official acts in county A, but the injury is felt in county B, and it involves damages, the case involves damages for injuries to the person, then under subsection 3, there should be venue in County B. So I don't think that's I don't think that's necessarily follows from the language of this of subsection 3, and because he's just making this argument off the cuff today in court, there's no case that they've cited that supports that proposition. We have cited a case that supports the opposite proposition. If the court looks to McDonald versus State, which is a South Dakota case that we cite in the section on the out-of-state cases, in that case, the plaintiff was a state employee who was fired in County A, which is to say his job was in County A, but the state authority firing him was located in County B. And the court held under a very similar part arose in whole or in part type statute. The state Supreme Court of South Dakota said, no, the action had to be where the official action was taken, in County B in my hypothetical. So reading in a hypothetical case where somehow the damages are felt in a different location where the official action is taken, I maintain the same position should be that the cause of action arose where the government action was taken. That is the majority rule. I don't know what South Carolina's cases Mr. Ard is referring to again, because they're not cited in the opposition brief that I read. It's clear that the weight of authorities, as many of these cases recognize, is precisely what the governor's interpretation of the statute. Regarding the threats to enforce, I just can't understand how the proclamation can be read to, as Mr. Ard puts it, explicitly threaten enforcement in Chelan County. It's a statewide proclamation, just like any statewide law of general applicability. But I don't see how there is a specific threat explicitly directed at one county or any other. The court asked Mr. Hart about the potential for conflicting results, and as I listened to his answer, I understood him to say, yeah, conflicting results are possible, but that's why we have an appellate court system. And that may be true, that conflicting results and irreconcilable judgments based on same statutes could happen in 39 different counties, but just because we have a Supreme Court to eventually correct that does not mean that that's how the venue statute should be interpreted, especially in the context of this statewide emergency, when the importance of clarity, uniformity, and certainty could never be more paramount. If we had different superior courts addressing identical claims based on identical legal theories, indeed brought by the very same lawyers on each side, it would cause public confusion, it would cause harm to public health, and it would seriously undermine public confidence in the neutrality and perhaps even the competency of courts to adjudicate these types of cases. A much better system would result by simply following the letter of the venue statute and transferring these cases to Thurston County, where they can be likely consolidated and heard together, and then sent up on review. Finally, just regarding the TRO motion, my point in saying that there weren't localized facts that were relevant to the TRO motion, what I was essentially saying is that if the court accepts the governor's interpretation of these statutes, which is to say that the influenza pandemic statute is inapplicable here and does not trump the governor's general emergency powers, then the plaintiff's claims are easily disposed of at the pleading stage. If the court accepts plaintiff's view, which is that any superior court in the state and any county can second guess the governor as to whether a state of emergency really exists in each individual county, then of course it's going to involve a localized determination of facts. And as my colleague, Mr. Even, pointed out, there's absolutely no evidence that plaintiffs have put in the record at this point that suggests that a state of emergency doesn't exist in either Chelan County, in Douglas County, or any of the other counties in which they've filed these lawsuits. If the court has no further questions, we'll rest on our briefs as well. And we would appreciate, just so that we have it as part of our files, if plaintiff's counsel would please serve us with the opposition brief that was filed in this matter as well.
Okay, thank you. So as I stated previously, I'm not going to make a decision. Well, looking at my calendar, I'm not going to make a decision today because I simply won't have time to go back through some of the materials that I needed to spend some more time with. And also, I am going to give plaintiffs the opportunity to submit those additional declarations that were submitted as exhibits to Mr. Ard's declaration. It sounds like Mr. Ard thinks he can get that to the court and served on defendants by this afternoon, is what you said?
That's my understanding, Your Honor. It's being worked on right now.
All right, and then I think that and again, I don't know, Mr. Even, if there was information that you had wanted to, additional information you'd wanted to submit to the court, additional links, you had said something about that. And I want to give you the same opportunity.
I don't know that that's necessary, Your Honor. I could take, I think what I would suggest is if the court wishes to delve further into the facts we discussed this morning, the Department of Health dashboard, the link to which is already in the record, does contain general statewide information. And I should clarify, that's updated weekly every Sunday. So, so there is a collection of data there.
Okay, all right, thank you.
Your Honor, if I may.
Yes.
Just having not seen whatever declarations plaintiffs' counsel will submit, we would just like to reserve the right to submit any rebuttal declarations that we think are necessary for the court to have a complete picture and a complete factual record based on this additional submission.
Right, so do you have I know you haven't seen them, but knowing what was attached to Mr. Ard's declaration, do you have a request as to time to respond?
It's hard to say, having no idea what these declarations or materials will consist of. We can commit to, after getting a chance to review them and discuss them with our client, to then filing something or apprising the court administrator of how much time we would like, whether by email or in a filing. And
if I may, Your Honor, I think perhaps part of the uncertainty here is that it isn't clear whether Mr. Ard intends simply to authenticate the materials that he already attached to his own declaration, or whether he's anticipating filing something beyond that.
Mr. Ard?
With the court's permission, we and trying to respond to the issues you raised during oral argument, authenticating the 2 or 3 statements that were attached to the declaration, which would include why the Chelan Douglas plan is labeled as a draft, a statement as to hospital capacity, which I understand Your Honor was interested in, and I think can be found as judicial notice from the county health. I mean, I think that's a document that's a public available document on the internet, of which the court could take judicial notice from the county health board. But failing that, we'll have something that would be, beyond publicly available documents, and be in response to Your Honor's concerns about varying behavior and localized testing, a statement about the nature of that testing and what's going on. So I think the latter 2 are additional, one of which may or may not be on some kind of local public health dashboard. That's a matter of public notice.
Okay. Mr. Even, does that answer any questions as to timing?
No, I think it leaves us in the position of saying we'd like to see it for our client, and then see how promptly we can get back to the court administrator with some idea of whether we think how much time we think it would take to provide anything in response.
Okay. Initially, I was thinking we could make time tomorrow afternoon, but I don't think that's going to give the parties enough time to get this information before the court. And I want to, again, make sure that I have all the information in front of me that I can consider. So I could set a hearing now, but for Monday or Tuesday, but I don't know if that's going to address the necessary time issues. It sounds like you want to be able to contact the court administrator and set a new hearing after that. I know the plaintiffs want to get a decision as soon as possible, and I don't want to delay that decision too long, but I also want to be able to consider all of their materials.
I'd like to be mindful of that consideration as well, Your Honor. I'd suggest that if this works for the court and for the parties, that we go ahead and set a hearing. If any concerns arise about the timing of that hearing, we can bring that to the court's consideration when we know that to be the case.
Okay. All right. So I have Monday, June 1st in the afternoon, and I have available as well. So I obviously will be doing it via Zoom at this point. I don't know if Mr. Ard, if you have your calendar in front of you.
I do, Your Honor. I'm open all afternoon, June 1st.
Okay. Mr. Even and Mr.
Honor, I
Johnson.
don't have anything that couldn't be moved.
Okay. How about, can we say 2 p.m. then?
Yes, Your Honor.
Okay. All right, so we'll reschedule for the court's decision for 2 p.m. on June 1st. And then if there is an issue with any materials needing to be provided to the court additionally, we can address it then. Okay.
Thank you.
All right. Thank you very much.
Your Honor.
Thank you all for your patience in having this set up. And also, I know this was a very long hearing, so hopefully everybody can take a
Appreciate all
breath
the time you took.
and get a break. So thank you very much. And again, I do want to make sure that everybody understands that I'm taking this these issues very seriously, and I am. The judiciary has the responsibility to address the legal issues, and that is what I'm going to do. Okay. So everybody have a good day. Thank you.
Thank you, Your Honor. Happen efficiently, and there's no reason to believe that the Superior Court of Thurston County couldn't take up plaintiff's TRO motion immediately upon the transfer. That court is, of course, equally well equipped to address the issues raised in the TRO motion. And I'll note that in plaintiff's complaint, most of the harms that are actually specific that could even arguably make a case for irreparable harm relate to the Memorial Day weekend, which is long past. Well, I don't know about long past, but it's past. So there's not really an equitable reason that or any sort of impending emergency that's been alleged